Open the portal for person and answer.
So the topic is there's no space at all, but you have to squeeze it through to get to the other end of the criminal law practice. My career has been as a judge on the other side of where you are, right? As a judge's perspective, I have my own bottlenecks. So it would be better if you can say to me what major bottlenecks, that's the problem that you face in getting through the criminal law of your petitions usually, or your applications which you put what the resistance you meet from the defense. Personally, I don't see anything there as bottleneck. Everything can be put through this bottleneck. Sometimes it's tight, but it does not restrict even for the prosecution or for the defense and for the judge. Now, one of the major bottlenecks that the prosecutors might feel is, the law is against you in criminal law. Everyone says that the law is. I have one of my friends. He is public prosecutor at Benoy. He says that law is for the. Whenever we meet, we have an argument and discussion. No, it's not that. I don't have that view. Why I'll say you later on. You are representing a big organization called state, very powerful. Practically, even if it may not have bestowed you with that power, because see, in our state, I see the legal system as still not understood by many of the educated people, including the executive, which includes the government. They take law as something which to be dealt as and when it comes. And for public prosecutors, I think they even don't care. Right? So, in that setup, you all are working, no doubt. I have worked with Ms. Sharma quite a long time. So, looking at her, so I understood many perspectives, but so we all have to do our job, and then inside the courtroom, or when the law comes, we cannot help each other much with our difficulties. I will have to include the law and the output. The prosecutor will also have to do the same. So, one of the major bottlenecks I would say itself is the position of public prosecutors itself in our state, in many states. Right? But still I have seen, there's quite a respect in other states, even if, at least inside the courtroom. In our state, it's the misunderstanding of this profession that people don't care, even for judges. You see from the executive, they salute us, they respect us as and when we are in front of them. But in the background, I believe that is, because we do assert our authority, because we know law. And even if you go to a shop and someone tries to, charge us more, we say it's wrong. So it's pointless arguing there and believe me, for a judge or a prosecutor or someone who knows law, you would be the last person to go to court for relief, because we know our courts. Even in my relatives, when they ask for something, I give them the easiest way out and settle it, because it's not going to do work unless the person's plea or case is very, very strong, worth going for a trial or civil suit. So that is the position at present in our state, everywhere I would say. So, and another thing that believe me, I used to confront one situation in court. With the police, and I tried to change that, but the prosecutor would not accept it. I'll be frank on this. I tried to change it. In some cases, the material objects would not come in time. Right? The judge has sat and the trial has begun. I think he has encountered many of these situations in law. And witness has said, where's the exhibit? He says it's in the.
We have case mediated.
Now we have to understand that. Now, why I felt this was, police always bothered. Police do fear court to the extent that, something we might write it as judges, but we are not their administrative heads. We cannot even pluck their hair. We are not their administrative head. We We can at the most, we can't even recommend the disciplinary process. We may say, he has erred in this, a copy of this order sheet will forward it to SP or whatever. That's all, and what SP does, we cannot interfere with that. So they know this very much. And sometimes my PP would say, there would be certain applications, they would say that the IO is not cooperative. Then I found that IOs don't even consider you as someone educated in law. Forget about PP. Now, why that is so? Now, PPs or even the defense lawyers, as per law, are the officers of the court. Second to judge in the court premises, at least, right? And then what I did was, I said, especially in remand cases, wherever remand, IOs would come with remand application, written nothing, what they would tell you, in CW, in connection with Sadar PS case number so and so, the accused has been arrested. We pray for usually 15 days for whatever offense it is. So many days of police custody. Now judge does not know what is the fact. He has not written anything. Now there will be some legal questions coming up which the IO is unable to answer. So in such cases I would need PP. And when I would ask PP, he would say, I do not know, he can just. I do not know. So there were this discordance. Believe me, it's only the state in Sikkim where IOs enter the courtroom without the permission. It's only in Sikkim. So it's up to you all to organize that. And I said, from henceforth, no IO will enter my courtroom for remand or whatever application they bring without bringing it to the notice of the PP, and PP who will plead it, not the IO. Of course, if I need IO to know something from him, I will do it. Then PPs don't mind. Then my PP did not agree. Later on, I was to stand in the door only, not enter the court, because I had said so. I told my made it very clear, no I will enter. Then I would ask my desk, why are you standing? Is something there? There is a remand. Okay, then call PP. Did he meet the PP? And the PP is not there. After the case is over, PP is gone. Okay. Then I have to give the remand, so I have to call. Then I talked to my PP. I said this. You used to say that IOs are not popular. Now I am trying to put you above the IO, at least in the court. And you don't want it. No, sir, please don't do it. I don't want. You don't want it. Because remands. See, I would not expect PP to stay after 4:30 and still ask for PP instead of IO. I would have understood that. But during the court hours, I wanted so that the IOs could be below PP. They had to come through it. But so that did not work because my prosecutor did not cooperate with me, to be frank. So practically these are the bottlenecks. You have to assert your position in the court. Otherwise, IOs not listening to PP is absolutely unheard of, to my understanding. The legal person. Now one thing they would say, there's one judgment. It's absolutely misread. That PP and IO, should not collude actually. You cannot collude and destroy the case. But IO can always consult the PP regarding the case. There was the problem. Only thing is your intent there should not be any malice against anyone, and it should be a fair opinion or a fair presentation. That case, it's a Supreme Court judgment, I don't remember the name. Supreme Court has said so because in that case it was found that the PP and IO had colluded, tried to destroy the case. On that context it was said. Now it was taken as a general observation and said, no, PP and IO cannot touch each other at all. And I think very soon the Directorate of Prosecution will also come in Sikkim. If you ask me, I'd give on a different opinion. I was asked opinion on this, but that was not heeded. What the police wanted was director to be someone from police. Right? CRPC says no. It is the advocate of 10 years experience in consultation with the Chief Justice of High Court. The state is amending CRPC. I think they have amended it.
I think they have said to them.
It has to go to President.
Yeah,
Earlier, they used to do it with the governor only, not realizing, but now someone might have enlightened them that CRPC amendment has to go to President. Probably President will accept it. So what's the point? My view was there, if you want to bring police up there, change you are bringing. Even now the police are heading, SP is looking into he's not the director, but he's looking at the charge sheet. But he's looking at, that's a different matter, it goes to him at least. Right? So I had said, no, it should be a lawyer of 10 years you could. Otherwise, if you want to put police, then what's the point of consulting Chief Justice as per CRPC? Why would Chief Justice consultation is required for a police? Is consultation required to nominate a lawyer whom he may have a regard and a person of repute who can do the job? And I thought some 10 years experience, a good lawyer would also get a job. And that lawyer would know how things work in the court. Even if director, because what do you think? They didn't want lawyer to be above police. And they have given example of many other states, some of the states, southern states. So I had said in that, you have given the example of certain states where police are getting the directed prosecution. But what outcome, what benefit it has come? You told. So the benefit. Then it's all right to make the police. Just in so and so state, some retired police is the director of prosecution, something. I again told, in so many of the states, it's the lawyers who are the director of prosecution. But when government wants to do something, it was just that, I gave that opinion in informal capacity, okay, not formal. Government wants to do something, they were bent upon making some police or whoever, whatever it is, as a director of prosecution. So they are trying to do it. Let's hope President doesn't assent it. But probably the President will assent it because he just acts on the advice of Council of Ministers, right? So these are the bottlenecks which should be removed actually. And one of the difference I saw among the police officers, why I am talking about police officers is they are immediately behind me in case of criminal trials. And I have been to Delhi several times, I have seen IPS officers. These officers know the law as much as we know in the court. They are so well versed in law, in judgments, practical processes in the court. But here, the police officers do not know because they are more engaged in law and order. No one bothers about. And one thing I told a police officer was, we are registering so many cases, we are arresting accused so many times. I told them, do you ever publish your conviction rate? Publish your conviction rate. Just don't say we arrested this. Just like there is sensitive case previous one. Let them in the end show the fellow got convicted. If he is really guilty, he should get convicted. But if you convict cases which are sensitive, what if anyone from Gangtok court? What about that factual rape and murder case? 100%. I knew at the time of the defense was Mr. Pradhan. He's acquitted, no? What's called? That cousin fellow, no? There was still a chance to convict him if it was a very good investigation. Even in that case, wrong person was brought before. Police were under so much pressure, and police knows the court also, they know us also, okay? And they knew that I would go deep into even in remands, because I did not give remands easy, unless I am convinced. So what they did was, they arrested two fellows, sent through some junior police, who had no knowledge about what's happening in that case. She was not the IPO. With no case diary, nothing, so that I would be put in trouble. They just said that we have recovered blood-stained shirt from these people. Now whether it's blood-stained or what, that was the only thing upon which they had asked me for 14 days. I just gave 1 day. I was totally convinced these are not the people. But I had no room also, to release them. If that turns out to be a blood. And I said, where is that object? Where is that shirt? They said, we have sent to forensic. At least they could have brought the photograph before. They didn't do that. So blankly they took remand. Considering murder case, I wrote that, that suspicion is reasonable, granted only for 1 day. The very next day they brought this real culprit. And I told them, you take these two people with all their dignity, announce in your vacuum that they are innocent. People have seen them in Facebook. This is how they are working. And if it's a very good sensitive case, they'll put all efforts. And if it's a withdrawal, they'll put more efforts. Withdrawal of prosecution. So, with this brief introductory, I need to hear the Mr. Indira, senior most of North, East, South and Gandhara. West? Bottlenecks.
Main difficulty as we are facing nowadays that we will not receive the sufficient reports. So the case is there. Even after examining all other social cases, we are not getting. We are to wait for.
Especially which one? DNA?
DNA.
Others?
DNA and
ballistic or
also ballistic. Doing biogas. And nowadays our officers are expert in. So expert now that there is so many cases like even Sharma over there.
all of the
We are facing a lot of reports. So this is one of the problems we are facing. Because without examining
actually, in some cases, it's difficult to frame charge also without that, especially in these drugs cases. Forensic Science Laboratory, supposed to be one of the biggest in this region. Maybe Northeast and North Bengal region, right? But look at its state. Apart from handwriting and that simple SATA drugs, they do nothing. Who is to blame? It's the government, isn't it? There are so many, there are so many.
Expert used to say that they don't have a lot of facility in that to conduct it.
Yeah, they don't have. No, last time they said they opened DNA. They inaugurated. Then what happened? There's no expert in facility they did it, probably. Now there are machines also, okay. There are machines which can give DNA reports in hour or two. There are machines. So it's the state which is not doing it. Now in machines also, the defense will always say it's a machine generated, not human. That's a different matter. With time that all things will change. But I wouldn't think that if you bring those facilities and advertise, there are a lot of people from here also. And another thing our state is bogged with is that, see, even I am a Sikkimese, a Nepali Sikkimese, I would say, right? They do distinguish in this also. But I don't mind, I won't feel anything wrong if someone is appointed from outside who is expert and can serve this state. He's not eating up the entire employment. If you can bring one be an expert. But as we all know, the Rule 4.4 offered by Supreme Court comes into play in appointing experts from outside. But as I said, if government wants, they can.
They can appoint even.
I've seen many biotechnology, even though one of my cousin is postgraduate in biotech science. He is running a homestay because that job is very rare in us and it doesn't want to use it. Okay.
There is only one expert. There are another expert.
Let's say three.
No, still something.
Go ahead.
One lady was there. Sonangam. One majority was not. Now there is no other person. So junior scientist. At least there are two persons. One person.
So the best thing for you all would be to meet law secretary, right? And I do not know which, but law secretary, even if it is not on the direct government, is someone who can be pushed to do things, no? Police to forget it. They're not.
Government has one person. It's still doing what our case and problem is.
तपाईँलाई अपॉइंट त law department ले गर्छ. Law secretary to my understand. Police भन्दा बेसी पोस्ट त law department हो भने should put forward the proposal to Home Department. That's why no one is bothered about legal system. No one is bothered because त्यहाँ पढ्यो भने मात्रै जान्छ and everyone sees law as something, जसलाई लाग्छ त्यो हावा रहेछ भनेर जसले लगाउँछ उसलाई चाहिँ law राम्रो रहेछ लाग्छ. So in one judgment, legally I can give you only this, okay? I can't say the government do this, do that. But it's up to you all. there is one judgment which if I'll get it, I'll give it to you. For some Joginder name I am remembering. What that judgment says is that the forensics are bound to give Supreme Court judgments, the reports in time. That's a judgment. Even Supreme Court knows. If you see, the forensic okay problem solved. Now these are all bottlenecks. All combined together is creating a problem. You all said that report does not come up. Forensics says that where the IO sends material objects is absolutely wrong way. Now if you send to forensic, let's say a blood stain which was not collected as per the procedure, they will receive it. They'll open it, they'll see it not as per they'll throw it in some corner. Unless you praise it, because if someone is getting a thing to be examined which is not collected or seized as per procedure, they will not be interested in examining it. To be wasting their time. There are far more other cases where a proper seizure procedure has been adopted and sent for examination. Now, who would like to examine a contaminated blood stain and give report? He'll put it at the site. He'll give priority to some other thing. This is one of the forensics what they say. Another thing is, see, where we send? Kolkata or Tripura, right? Chandigarh, Hyderabad. Hyderabad ka alikati seat gardiन्छ because theirs is a very big one. Technically sound also, right? Uनीहरूको exports are बचिरहेको छ. Kolkata I think is a very big state. West Bengal को डल्लै हुन्छ. Why would they give priority to Sikkim? हाम्रो त्यो के हुन्छ? बाँकीमा गर्दै जस्तो. त्रिपुरा नि त्यो बाँकीमा गर्दै जस्तो. They are not bound, no? So that is another reason. So till we have our own, believe me, nothing will come. It won't come. You will have to work this way. And every time forensic report, if it's a DNA, okay, if it's a ballistic, if it's a gunshot, then I think we will have to wait for that. But in DNA, if there are evidences, then there was one instance I remember. It was a case of West Sikkim, where the victim, it was a POXO case, if you have heard that. Victim implicated. It was a relative of father accused, right? Evidence of victim, absolutely reliable. And in the meantime, the DNA samples had also been sent. I think the child was born. But the report did not come and the judge pronounced the judgment convicting the accused. And accused preferred an appeal in the High Court, and during the pendency, the forensic report came saying he is not the person. So that danger is there. Now what I saw in this was, I have not read the evidence of the victim at all. The only danger for the court is this, if it comes otherwise. Otherwise DNA is merely corroborative. It's a scientific evidence. Now but the law is, this could be funny, I don't know. The law says, if DNA says yes, it matches, it may not be 100% correct. But if it says no, then it is no. Okay, law is this as of now. So, still legally if you see, if judge has, I think the judge who pronounced the judgment in the West was absolutely correct. Even the High Court said judge should have waited. It did not say much, okay? Because that's merely corroborative. If the victim says, no, he did not rape me, what will you do with DNA? Even if it matches, can you convict? Cannot at all. That's science. And the court till date does not believe science. Even I used to doubt science. Till the date I first time flew in an aeroplane. I am from science background. I studied science in +2. But that curiosity of mine, is this true, whatever the books are saying? Okay. And when I flew for the first time and I saw the ground below down there, I just said this is science. I was experiencing. So the courts have very little experience of science. What they have experienced in science? I don't think so. So even the law, it's a British type. And till date, if you see all the laws, they disbelieve science and still say that it is just the corroboration. But if I may give you one, I think I'll find this judgment, okay? I relied heavily in decreeing a suit. It was upheld by the session and district judge also. Have you ever heard that it is just corroborative and it cannot be relied.
Yes.
I'll show you one Supreme Court judgment. It says no.
So there are some judgments.
This is like
Yeah, some found only one. There are not some.
scientifically accurate job on it.
DNA test is accurate science.
It is
One
accurate
student.
on it. Say what Kamti Devi versus
Yes.
Kosiram, I think so.
And it cannot be decided. There is a
This is like it is
No, no.
scientific.
It cannot be. What if the victim says he did not rape me? Can you
Um,
use DNA?
Then in Nanda, there's one Nandalal Vasudev versus
As the law stands today, okay, it might develop that. Okay, we agree.
Nandalal Vasudev by Dwapar the case company. It was the case that the husband and wife case through. It was for compensation. Providing. So like they had the wife had the husband had filed a case against the wife saying that she's not my wife. So the court had advised for a DNA. Then both of them agreed and they did DNA analysis for the result. It came like initially they were married and there were no kids for about 10, 15, I think more than 15 years. Then later on she went to a maternal place and came back. Then again she stayed with the accused and she had a child. Then later on the husband said that this child is not mine. So for that the case had been filed and the court advised for DNA. Then the DNA was done. Once it was done, the report came negative. Then again the wife did not agree. Then they went for second time DNA. Then also the report came negative. Then the court held that no, he is not entitled to pay any compensation. But whatever compensation was paid to her so far, it cannot be paid. So that was the
Yeah, that's what, when it says no, it's absolutely no. When it says yes, then let's take an example. The victim has said, no, he is not the accused, he did not rape me at all. DNA comes, yes, what could do? I would not could.
As a corroborate, it is used as, and there are many case laws which says it's just a
Because there's a human
corroborative
being
process.
saying to me in front,
Answer.
he's not the one, though maybe a lie, okay, maybe a lie. Maybe true also.
It is not corroborated. And
Corroborate is enough.
we cannot take that. A victim death is the one.
That's what.
There are cases. DNA
Australia bias,
was-
sir,
No,
victim.
there was just one judgment in a court, one Amos King's case, and he acquitted. The report was positive, but he acquitted the case. Not in terms of like the doubting the DNA report, but in terms of like the victim saying that it was consensual.
Another thing in this DNA, the method of collecting DNA is found, if the judge is well read, found to be wrong, it cannot be relied upon. Now what police never can prove in our case that it is the blood of this person. So casually. The Caesar one comes, it's a criminal law, no? If it is a civil case, the judge would have been a little bit easy. It's a criminal case, it must be fully satisfied. That yes, this blood is of the person, nothing happened in between, it is intact. Even that Nirbhaya case would not have been convicted had the police not worked in that case. And that was the actual usual work which they should do. Okay? They are working only in those cases where now see we have to do the work properly and fully. Okay, so if you see that Nirbhaya cases judgment in that one, every single thing picked up from the floor has record, to whom it was handed, where it was kept, till it reached forensic. That tight is the investigation. And believe me, out here if the investigation is tight, none of the cases will get located. Except a few rare, because of
case in
If
Gangtok.
they start dealing with that kind of thing, so in all the cases will get
half of the
What
case is dead before it comes to the
Yeah,
court.
what the IU does is like, while collecting, Jyoti might remember there is a case in Gangtok where, well, I public prosecutor out here, the IU is to stamp in the paper from the doctor has to stamp it and sign it that I have taken the. Instead of that, the police officer SSO is to put it. And such a blunder, Professor was asking, what is this?
The chain of circumstances is not there.
They take it so easily, so we
That's
can do
why
anything.
even I have conducted few cases, ignoring all these things. But if there is a good defense lawyer who challenges it, then the judge would be bound to acquit. Okay, yes, chain of circumstances is very, but it should be actually, it's a mantra in every case, in every judgment where there is seizure. Judges are not writing it. Okay, be thankful to that, they are not using that. If chain of circumstances is to be used by a judge while writing judgment, over all seizures will fail.
Yes,
All seizures will fail.
exactly why the judges are just overlooking this is because most of the cases come with their
That's
authority to chain of circumstances to establish a
You know, if
most of the
I
cases.
always said that if I would go by the standard of law, I would have discharged 70% of the cases. Discharged. Forget about trial. But, you know, I have less cases. Prima facie only, but I did minimize, you know, I discharged quite a lot of cases.
Seizure as far as SARA and ambiguous is concerned, that IU is to do nothing, it never follows anything. And the whole case, entire case is acquitted in confusion.
Sometimes, you know, by some misfortune, the fellow gets convicted. One person in the career.
No, the DNA that is taken from CID to.
Now you said that Pakistan case is acquitted.
Yes.
You should have, you know, reported it. Poor. Now after acquittal, I would say him a poor fellow, because I am a legal person. I am not concerned about what occurred outside. Okay, that could be a personal view. I cannot speak it. I speak legal view only. I would say him a poor fellow. So for trial, whatever it is, there was no guarantee, even because I have to tell you, two wrong persons were brought before. So there is no guarantee also the second person. He was just produced on the basis of confession and a recovery of one rope. That was the only evidence in that case. Okay, and they never produced him for judicial confession also. Even that judgment is quite good, you know. Not used every time, but I feel that sometimes it can be used. Very much. This was a case of forgery. But a civil case was filed, saying that the fellow was not required to pay the bank's loan, and he won it. Who forged it, God knows, but it was forged. Now, what I found in this was that, you know, the above judgments clearly hold that it is not a requirement of law that uncorroborated testimony of a handwriting expert cannot be accepted. The science of handwriting is still an imperfect science, and the evidence of such expert must be weighed with caution. Now, just see this judgment. In this judgment, it says, we will first consider the argument, a state argument often heard, particularly in criminal courts, that the opinion evidence of a handwriting expert should not be acted upon without substantial corroboration. We shall presently point out how the argument cannot be justified on principle or precedent. It's a Supreme Court judgment. We begin with the observation that the expert is no accomplice. There is no justification for condemning his opinion evidence to the same class of evidence as that of an accomplice and insist upon corroboration. True, it has occasionally been said on very high authority that it would be hazardous to base a conviction solely on the opinion of a handwriting expert. But the hazard in expecting the opinion of any expert, handwriting expert or any other kind of expert, is not because experts in general are unreliable witnesses. I think this is quality, it has been quality. The quality of credibility or incredibility being one which an expert shares with all other witnesses, but because all human judgment is fallible, and an expert may go wrong because of some defect of observation, some error of premises or honest mistake of confusion. The more developed and the more perfect the science, the less the chance of an incorrect opinion, and the converse if the science is less developed and imperfect. The science of identification of fingerprints has attained near perfection, and the risk of an incorrect opinion is practically non-existent. On the other hand, the science of identification of handwriting is not nearly so perfect, and the risk is therefore higher. But that is a far cry from doubting the opinion of handwriting expert as an invariable rule and insisting upon substantial corroboration in every case. Howsoever the opinion may be backed by the soundest of reasons, it is hardly fair to an expert to view his opinion with an initial suspicion and to treat him as an inferior sort of witness. His opinion has to be tested by the acceptability of the reasons given by him. An expert deposes and not decides. His duty is to furnish the judge with the necessary scientific criteria for testing the accuracy of his conclusion, so as to enable the judge to form his own independent judgment by the application of this criteria to the facts proved in evidence. It again says in this judgment, we are firmly of the opinion that there is no rule of law nor any rule of prudence which has crystallized into a rule of law that opinion evidence of a writing expert must never be acted upon unless substantially corroborated. But having due regard to the imperfect nature of the science of identification of handwriting, the approach as we indicated earlier should be of one of caution. Now this judgment says, it's not required. The judge is convinced from the handwriting. It's a substantial corroboration. Some kind of corroboration is required to a certain extent, okay? But it did not have substantial corroboration. One can keep this judgment in Muralihar was a state of Madhya Pradesh with the citation. The district judge has quoted this judgment in accepting, in rejecting the appeal of the other person.
So the judgment is Muralihar versus.
Stage of confusion.
This judgment I used, there was no substantive corroboration. The only thing I had was this. Yes, the allegations were there and they came and proved it also after moved to the one in.
If the judge is
Convinced. And I did exactly what this judgment said. I did not say, oh, for expert said this. Expert for reasons and for conclusion, and I myself examined the handwriting. I could do in that. It's difficult to do in vigilance cases, okay? There are a lot of handwriting. But this one had only one set of handwriting was to be determined. So I did what exactly the expert was doing, understanding his reasons, and I reached the same conclusion, that this is a false one. So on that basis, I was absolutely convinced. And you know what this fellow did? Once he won the civil case, he lost an FIR for criminal. And then, I don't know, there may be some bargain. They knew it later on. No, it was, actually the fact was, loan was taken. I knew that. It was the father, it was the daughter, in daughter's name the loan was taken, but used by the father. Later on, father died. Daughter did not want to pay. And she stopped paying the aid. There was no way out. I do not know how bank worked that false signature. Bank may have asked someone from the family to acknowledgement to avoid limitation. Bank issues acknowledgement. Once the acknowledgement of debt is there, then the limitation again runs from there, for 3 years. So on that document, there was a signature of the girl. And then bank said, see, there is an acknowledgement. She has not paid. 3 years time again runs. We are well within time. Kindly pay back. The girl said, I did not sign that. And she was true on that. The bank somehow, either they themselves signed it. And funny thing was, bank was the tenant of the girl. In their building, there was the house. And the girl was in USA, settled in USA after taking ownership. And then once they found that civil case was, they lost their FIR, put the bank in trouble, manager. I think they have.
Also there was a similar case, like Prosecutors was there as a similar case, but in that the father had actually signed his son's, he had taken loan on behalf of his son, submitted all his documents, and he had forged his signature. That there also I think handwriting expert for that. So I don't know the fate of the case because.
So in the early session we knew that forensic is one of the bottlenecks. You can only use law unless they develop that one. You all will be getting reports later. And this case will be stuck. Even the judge cannot move forward. No matter how many times the judge says, see, it's getting late, do something, you will not be able to do anything. And the judge will also be not able to do anything except that judgment which I have.
but they didn't research on the case was happening.
Our crime will also ask them, they will say that it's being done, being done.
Or only duty as a prosecutor is to make frequent communications with the IO regarding the status of the.
No, even in that case, they will not, what
But
poor sub-inspector.
but at least that is court command say we will be answerable to that
It can
extent.
be done.
In order to avoid,
Or to seek further.
the defense will be questioning us all the time.
कतिवटा केसमा त्यसो मैले आफै फरेन्सिक एकजना फेला हुनु उहाँहरूलाई कन्ट्याक्ट नम्बर राखेर सोधेर त्यसरी पनि उहाँ अब त्यो सबै पोसिबल छैन किनभने कतिवटा डाइरेक्ट हुन्छ कि हामीले यो डिस्क्लोज गर्नु नम्बर चाहिँ हामी दिनु हुँदैन उनीहरू पनि सिक्रेसी के हो किनभने गो एन्ड फोर्स त्यहाँ गएर केही मेनिपुलेट गर्ने चान्सेस पनि हुन्छ सो दे आर नट अलाउइङ द कन्ट्याक्ट.
And one wrong thing that the police do in sending things to forensic is, एउटा सिजरको त भयो अर्को writing the history of the case, saying who is the accused. It is easier for forensic to reach a conclusion, a wrong conclusion, because they are also bogged down with work. If you tell, why to tell the history of the case to the expert? I don't know. Tell him, I am sending this, and I read this, finished. Obtained from accused one, then forensic, there are so many works and you are putting pressure on that person to send the report. You'll either say yes or no and send it. He will have hundreds of reasons to give. He'll give equally good reasons for both things. Come and depose in court also. So that is one of the things which is wrong. And that becomes, when I used to read that history given to the forensic expert, no, I really did not feel like relying on those experts. It's already in his mind which sample is of accused, which is of what. Only to say. Even in DNA, why is it required to say this is of baby? Match these three, what is matches of? The other records should be here with the police. You say score, you say score. Then expert opinion comes, then you say, see, I have done this. It will look more perfect. So that is one thing. Other bottleneck is
So the things that sometimes the witness, particularly the doctors who examine the victims in some other cases, they transport, I mean, they went to
study.
other states for further studies.
Yeah.
And
You can do to BC, first of all.
no, BC members, कतिजना चाहिँ कोअपरेट गर्छ some of the most of the victims not cooperate. एकपल्ट फोन गरेर चाहिँ हामीले टाइप गर्छ अब बोल्दै फोनै उठाउनु.
No, you
So
tell
it's
them.
very difficult for us to contact them. And
Why do you have to contact them?
no, पुलिसलाई पनि त कहाँबाट सोच गर्नु पर्यो. नभए चाहिँ साल हुँदैन. अब उहाँहरूले उहाँ गएको छ. फेरि उहाँबाट चाहिँ अब रेस्पोन्स टाइम छैन. ट्रेनिङमा हामी we are busy in training, so we are not able to. And those facilities for the video rooms, सबै facilities.
You tell them that if you don't come, the court will issue warrant.
That particular place.
Tell them
What is one case?
All to be
We are bound to drop that witness and then examine the superior officer.
no, that's
To
wrong.
identify this.
How can you do that?
And that is also wrong.
That's absolutely
We can't exactly prove the
If it's a case of acquittal, then yes, you can do it.
Yes.
But you have to say it's okay.
कतिवटा
It's
केस
a case
Yeah,
of
you can
conviction,
come and,
you will be risking something.
मैले एकवटा केसमा त कतिवटा त्यस्तो पनि भएको छ.
Acquittal मा
Why
त
छैन?
get it over. यसो सबै याद भएको हुन्छ कहाँ
अहिले पनि
के केस
भन्नु
कहाँ
उहाँबाट
जाँदैछ.
रेस्पोन्सै छैन उहाँले त
And I would like to report that at least you can at least identify the report, if not the signature.
त्यो त obviously
Then it will ask the case of
कतिवटा केसमा त भिक्टिमै अब फ्यामिली नै सिफ्ट गरेर नेपाल गइदिन्छ
त्यस्तो पनि
अब त्यसमा नो एड्रेसलेस त्यहाँदेखि चाहिँ
त्यस्तोमा त अब सबै हेल्पलेस भएको जस्तो it's already.
some of the cases witness also expected about
But when you say drop, no, even the court cannot see. Whenever prosecution said we are dropping witnesses, I never wrote accepted. And in the cases which cannot be accepted, I insisted unless every method failed to bring the witness, I said okay, no. Because this 311, no? How can a court not examine a material witness? Just merely prosecution says we did not get it. Court ले report गर्ने पर्छ. At least there must be on record. Person was tried to be brought about that.
IU like बनाएर then you examine the IU like examine गरेर
court witness
court witness बनाएर general पाउँदै पाएन भनेर it is his prerogative.
And don't be sweet to the doctors, why would? Of course, it can be. But if they are harassing you and say, I have to study, I am getting this asking someone to attend your marriage. They said that, okay, if you say so, then warrant may come from the court. For you know what, our case answer. They tell the courts, Your Honor, issue the warrant. I am unable to bring it. That's one of the bottlenecks if I will ask you. Why to be easy? You have to be professional in your job. No? Even me, so many police did not like me when I was. Many never would like because what I said was true. Many would talk at the back. Whatever cases. If you die, when you are dying, only your family will be around. Right? Some of the friends and the closest one. Well, hospitals are check well, I have to do. If they doesn't go to the superior of science, then there are so many doctors. If you have to avoid someone for good medical treatment, let's avoid. Don't do that. So we are very senior. Forget it. And you talk professionally outside. If you talk well, without forgetting all those things, what happened in profession, and still they don't talk, then that's not your problem. It is. What's the solution? No solution. That should be well equipped. It will never come. Never come. And the way the cases are increasing, and the way the police are now using DNA, then it's all hope against the hope. But maybe it will grow. Now, in the second phase of ECO's project, I think most of the doctors will come from ECO because the project also wants to give the cameras and television to the hospitals so that doctors don't have to. And slowly it's moving to EOK. Now in this phase, probably 1 or 2 jurisdictions will be paperless, beginning from bail, etc. So in future, yes, the forensic reports may come through electronic means also, because now there is a process of joining into play. Joining forensic offices also, land revenues on the joint sides or land revenue records. In future, courts can just at the click of a button obtain the revenue records, particularly in the civil case. Last time I don't know, I forgot one more thing we joined in over that. Now the third one is with forensic. So as of now, in future maybe things will improve, but it will take time. Now another thing I felt for prosecution, very sad, was section 311A, handwriting murder. Can you take a handwriting of a person who has not been arrested in connection with the case? 311A says so. How to take the handwriting of a victim, sample of a victim or complainant? 311A says a person must be arrested. I was very much confronted with it because police were coming with application. I rejected 1 or 2 saying that no, a person who is not arrested cannot be asked to give his sample handwriting. But I was feeling inside my mind, how can that be done? What to do in an investigation? So the way that I found was, if you want to take the sample of a complainant or victim, permission of magistrate is not required. 311A is only for accused. If you want for accused, come under this. If not, you can take it yourself. That's what I said, and otherwise what police were doing. In the complainant program, arrest correct. You section later on the arrest one person. That you take it yourself. Don't apply it to me on the 311. So I did and found a way out. Substantive rather than the process that went through. So that's what I said. Let me think, what prosecution never filed any application, but 311 is put out. Prosecution never, so that's why even I'm not very much experienced in what prosecution faced actually, the problems. It could be there in their minds also. 311 पूरा deal करने वाले CP को बड़ा और उनका hardly defense बड़ा तो पूरा होता है.
Section 35IE Act is a major setback for us in terms of box offices because it is with regard to the minority of the victim, your entries for judges. So this has become a major
के भन्छ यसमा चाहिँ?
You see the entries, whatever.
It says books of account.
Implement by a public servant is
Entries
is-
जति पनि छ, the person who is making the entries has to be examined in order to prove the authenticity of a document.
the content of
Content.
The content of the document. You see, like the birth certificate, also the registrar comes, he gives his evidence. Then what happens? त्यसमा नै
Does this relate to the birth registers section?
त्यो section 35, if I'm not wrong,
Advance says account.
IE Act, Indian Evidence Act.
No, okay, 35. I was reading 34.
24, IE Act, pertaining to the entries made in the document.
Document.
Live birth register later also, the registrar says that yes, the entries are correct. But the person,
Who
because
have
most of
been
the entries are made by the dealing assistant.
some other person.
So that
Or
person
staff
is,
of the-
that person is no longer.
Either retired or
or
died,
something like
expired.
that. Either the
See, if that 32 can be used, okay? Otherwise, even I have to up to you. See, I'll tell you one example. This you are not telling, even everyone would tell that this is the problem because now would you accept someone as a prosecutor also speaking for victim instead of bringing the victim? Your prosecution would bring victim. So it's the same similar case also.
But that is
No, that I
quite
should
a-
find it. Even I saw this, you know, I rejected in a sense. In the end, it would matter, you know. Why would I believe the person who did not really do it?
the end.
Police need to search that person.
No.
See, the thing is this, no, if they don't find it, tell the court. Police never bring the truth. No, that's the problem.
They never
Court is
identify
not
the fact.
against. Court is only against falsity. What creates doubt in the mind of the judge? Falsity. Likelihood of falsity. Okay, now, if the police goes to find that particular dealing assistant, he finds out that he could not be traceable with all best ability he did. Court will understand it. Then okay, even if you have brought the next one, court will consider that and will have a reason to say, see, this fellow was not found. If he has died, 32 is there, evidence there. The police doesn't say anything. They directly put that to some other witness, and there's no explanation to it what happened to the real witnesses. That is the problem. I always told the police, don't try to make out a case. Even if you think you are losing it, give the truth, you might win it. यता पनि बटारेको हुन्छ त्यो नमिलेको कुरा नभएको कुरा मिल्दैन भन्छ। There was one case, you know, I acquitted only because of FIR. Now there's a usual saying, FIR is not a substantive. That's true. It's only corroboration. But FIR also has a value. It contains the truth of what initially happened. Now all the evidence must prove that fellow was notorious of Aritha, pensioning something. And then one day the drunkard said he goes to a liquor shop off-shop, and the girl would be on the other side, and he asks her for liquor. Then gives some water bottle. He doesn't have money. He says, I don't have money. Then there's an argument, as per the story. And then there's one stick out there, in that shop. The girl lifts a stick and tries to show. He holds on the stick and hits her. Said to be hit on the hand with sudden injury. And then police are caught, so what happens in the FIR. The case went on. The girl said everything on this. But you know, in FIR, it's not mentioned that she was hit with that stick. The fellow came, argued with me, did not have money, but that's it. So why would someone not write the real thing which led you to file a police complaint? And I wondered how police also registered a complaint when the girl has no criminal, except for trespass. And in that what had happened was the actual thing, you know, the IO was very furious. It was the only IO who challenged that judgment, but still it was upheld. Very what to say, one IO is there, you will know I won't take it. What she had done was, the girl rightfully went. Police destroyed the case. The girl rightfully went. And who's the accused? Oh, let's see. police took the victim to hospital, made some kind of exaggerated medical report on the advice of police, came back, police maybe himself wrote the FIR. I don't know, something went wrong there, they couldn't mention the crux in the FIR. So, ultimately I even commented upon the IO, and the very person was the IO who took before registration of FIR to the hospital, all those not required for a simple injury of the, and then they destroyed the case. The case is destroyed if the FIR is not written properly. The case is destroyed even after that steps are not taken. And by the time it comes to court, no, it's so fragile. हुन्छ नि एउटा त्यो आशै जान्छ अनि कहिले होला कन्भिक्सन लेख्दा त यस्तो टिङ्गटा लागेको जस्तो हस्पिटल लेख्दा and you know prosecution has very difficult case and some big cases also, even vigilance cases, all the vigilance cases I did was okay, very good investigation, but far better investigation than the ordinary case vigilance one. It's quite interesting. They failed because of some here and there's mistake, because 420 sections, you all know, it has so many ingredients usually. That was the reason. And, okay, in this one, no, I think there's judgment of High Court also in this.
There are many reasons.
There are many,
Especially of Lordship Pascal.
Yes, and
Some
legislation
agreeing with it. No? An entry in any public or other official book, register or record stating a fact in issue or relevant fact and made by a public servant in the discharge of official duty or by any other person in performance of duty, especially enjoined by the law of the country in which such book register or is itself a relevant fact. Yeah, it has to be proved. This document can be brought. Now it's a relevant fact, what has been brought. But this relevant fact needs to be proved. So the person who made the entry has to
that the registrar who comes, some they know the name of the dealing assistant, then
still it is not solid. You
but
can call them. Yeah, I have done in one or two cases to ask to bring the real person. And police have brought it.
some come and say, the registrar say, I do not know who had made the entries. So that makes it futile.
That's a fraud investigation. It is a fraud investigation.
डक्टरले फिल अप गरेको हुन्छ द्याट स्टाफले गर्छ
Then
त्यो
it's actually
Then
it's
doctor
not.
has
No, in that case, no, to my understanding, the actual registrar who signed the birth certificate can be brought. See, feeling is someone understood. Okay, but then what's the point of the registrar's signature of the? He must have the knowledge, no, of that particular fact.
No,
You cannot sign otherwise.
No, sir, not about the birth certificate issuing authority. It's about the live birth register entries.
When will
They
they
produce the big documents, live birth register in
No,
which
on that
the
basis,
entries-
birth certificate is made.
Also,
Yes,
on the त्यसमा चाहिँ जोले entries
Entry
बनाएको, those people are the dealing assistants because the registrar themselves don't make the entries in the
Okay.
register. So they come, registrar comes and says, okay, this was issued. Some are issued in their during their tenure, but the live birth register is brought.
I completely understood. I don't think this is true in all the facts of the case. See, if I have a case where the victim has deposed, there is no severe dent in the birth certificate. Okay, the other evidences are convincing. And see, त्यो जुन चाहिँ registered भन्नुहुन्छ त्यसकै extract त हो birth certificate, and the registrar has signed it out there. Now, can a registrar can come and say, see, I do not know what was written there, I just signed it. Signature is a responsibility. No? I am saying, yes, this birth certificate being issued to her is genuine, taken from this live birth and register. And then a fellow can always say, yes, it is matching. It's live birth and it is the extract taken from her. See, in official, I would say no. Maybe I do not know about that interpretation. Officially, things are done in a particular way. So if you insist, the top boss, before signing it to go down there, read again, then what's the point of having that hand? I would not interpret it that way. I would give some way out, okay, if I am convinced. Now in some cases what may happen is the registrar is not sure. Then now you need the person who made the entry. Now, even if you bring that person, might say, see, on the basis of it given to me, I filled it in. Now, who gave it? You have to go there also. High Court judgment is there in this context also. If we go by that judgment, we will have to trace down the first person who
Yes,
came out.
actually,
Yes,
that
yes.
is the problem. The defense of, like, they are resorting to that judgment.
So that's why.
And we
Let
are,
the resort, you have to give a big argument. It is not applicable in all the facts.
but it all depends upon the presiding officer, how they interpret it,
The content of birth certificate is proved by registrar.
That's what, they want to go to the.
If you see that
That's
judgment,
okay.
I don't know, there are many other, but from where it began from the High Court judgment, I still remember. It has met very strictly standard of proof. Rightly so, I would say. That case had a peculiar factor where it had to go down there to reach a conclusion.
Each cases should be
Yeah,
dealt in
yeah,
that
different
manner only, but the defense, they always resort to.
See, if the court is convinced with the birth certificate, no matter how much they argue, it's pointless.
And another thing is that, but there's a good judgment also of the High Court which says like if the parents come and they say that, yeah, they don't.
Even I have used that, especially I have to deal with kidnapping cases.
The prosecutors.
I have to deal with kidnapping cases, so even if prosecutor did not ask, I have to ask. नानीको कतिजना चाहिँ आमा बाउलाई नि हान्छ
त्यो हुँदैन
प्राय
प्राय
लिएको थियो उल्टा भनिदिन्छ उल्टा भनिदिन्छ if you don't record that defense jumps.
Yes, yes. And they will wrong
You are not recording
the
it.
data.
So I'm bound I'll have to record it. So it's dangerous to ask also.
Yes, yes.
Be
That's
careful.
a tricky,
But
Be careful
now,
how, you know.
but now I could have several judgments said that why mother and father are not brought to prove the date of birth of the.
Yes,
Yes,
it
we are-
is.
Nowadays like we are trying 311 so much.
No, I think. See, in the mother or father, when you case for where the parents they bought, I got wanted to convict. It was a case of conviction only. Then they used that to convict. No. My parents have said it, relied on some Supreme Court judgment and said yes. Okay, now it's not that every time they have to be brought, no. See, Juan is that you can wait till the end. If you feel the birth is not proved, petition the court, rely on the High Court judgment. You want to examine, this is a material witness to prove the end. Kindly call the parents. Okay, now they might say, come and say, ulta also. But you did your job. With best intent you did. You must otherwise prove this.
आफ्नै नानीको नाम पनि याद
No, I have done it.
they have that nickname.
Recently we did one case.
पहिले जन्मे
No, no, छोरीको नामै थाहा छैन. आमा विक कल इट वाज लास्ट विक only. छोरीको नाम के भन्दाखेरि नामै थाहा छैन अब. Then what we can do?
त्यो आफ्नै
No,
नाम
why? We must see this
आफ्नै नाम।
cases. See,
बोलाउने.
some people say about 15, 16 also girls are there. Okay. Some people say, maybe see, especially Eastern majority, women say. I find that women are more enemies of in this matter. Okay. Now 16, 17 girls, she had a sex. See, it could be natural thing. Nowadays children grow up, but the law is there. But I have not seen it. Have you seen the rich parents? Are they not involving in physical relation with their peers of that level, of that status? Obviously, those cases don't come to us. Okay. Now, I see the girl from poor family. Broken family is always a history there. And the girl was not brought up properly. What she said? I did not avoid it, that's all she said. Was she aware that, it's my body, it's my right. I will give it to person whom I want to give. It's not this awareness in her. Everywhere it's happening. Yes, we did it, I did not object it. But she did not do that thing with an awareness. No? Okay, I'll explain it. It's not that. In many cases. So I see them as sympathetically and people, oh, 16-17 बजे तो पूरा बुझ्ने भएको. Occidental हुनु पर्ने हो क्या? Because that boy is of less age, it's very pathetic.
Sir, what do you say? Sir, sometimes elder men tend to make use of such girls.
That's right.
Because there have been instances where bichara bastibara ghumnu aayo yaha, then he takes her around, they chat, then he takes her out and makes her pregnant, and after that she goes, then bichara she calls him so many times and he doesn't receive the call. She tells him I'm pregnant, he doesn't attend the call. So there have been instances like that.
So I was attending one training program at Fox. So the ones who actually drafted this laws, not the draftsmen, but who NGOs, They were saying that they had put 3 years exception.
Level of consent.
Consent. 3 years they got. But no, someone had even some of them objected, and it was removed. That means if the age difference is of just 3 years between the boy and girl, consent should be seen. And this will come in near future. It's a nuisance at present.
And the age level of consent also should be brought down, I think.
Because if in human right, justice, if you can test the mental maturity of a 16-year-old boy who has committed innocent offense, why not of a girl in a boxer case?
That is much required. That is one of the bottlenecks.
Have you read one judgment of West Bengal? It is acquitted in boxer and law relationship.
Yes.
Such a good judgment.
The defense are making use of that.
Such a good judgment. The way he has written it. But the problem in our jurisdiction, the High Court directly, एक थोड़ा judgment the सब, the law applies a consensual version, but the law is not. That is precedent for us. So we cannot rely on that Bengal judgment. Unless some judge writes very well, not to break the precedent out here also, and to follow what is written. It's quite a difficult job to understand. And one of the things, Poxo is here from here. Can you bring Poxo direct? One of the sentences accused are not using is, see, in this relationship, if I would have been a defense, I would have argued this. Does Poxo require guilty mind?
Yes, the motive is also required. Section 30 says culpable mental state is very important to assess the commission of the duty. So till state it cannot.
What I guess was not. See, you can. How does the court derive intention? There's no direct rule on the acts and all those things. No. If a 40-year-old man is having sex with a 15-year-old girl, then the court can usually derive intention. See, you are having a person of your daughter's age, therefore you had culpable mental state. But in a love relationship between, let's say 16, even up to 21, I would say, the boy, where was the culpable mental state? If she was consenting. Though the law says that consent is immaterial, in cases of, especially in cases of where a marriage has occurred. Now after marriage, sexual intercourse is a natural follow-up, right? And when they were having that, did the fellow think that he's raping? Was there in his mind? Not there. If I become a Poxo and I find this case, I'll off it on this ground.
This observation has been made by the Hon'ble High Court also regarding section. The most of the defense they don't take leave of section 30.
Yes.
So there's already 29.
That's what.
But in order to counter 29, there's always a 30. So, but they never take leave.
That's what I want to tell. Why they don't use this section? Now, but there is I discussed with one judicial magistrate also. He is of different view again. But I still disagree with him. He says this culpable in any prosecution for any offence under this act which requires a culpable mental state, but it shall be a defense for the accused to prove the fact that he had no such mental state. Now, my colleague says that this pertains to only doctors, some who are involved in the case like police. Let's say doctor examining a victim. Now that finger tests are also not allowed by the law. If there was there, then the doctor would, if we are mere doctors only, hardly they take to female, okay? Inserts a finger and the girl complains that you did this. He says it is only for those people this is there. But I said it's not written like that, no? It's very general. How can you restrict it to that? So, but a thought-provoking idea, opinion that my colleague also gave could be, God knows, that it can be interpreted that way.
It's not that strictly.
So I felt that the fellow who got married with the whole family around and in the night they have intercourse, where is his culpable mental state? Right? I felt that way.
But none of the defense are taking this.
Yes.
Take leave of section 30 processes.
And there is judgment of isn't bench of Justice Bhaskar. Now you said intent is required. Number 3, intent is not required. Intent is required if we go by this section, only in sexual assault.
Sexual intent. In section 7.
That's what.
Section
That's what.
It is.
Only there it says intent. All others whoever. It does not talk about, but there is a High Court judgment which says, quite interestingly, I do not know what would be the consequences in future, but the High Court has given some way around for the defense to work it out. I do not know why.
But they are not getting the hint and they are not using it.
A person is said to commit penetrative sexual assault with intent on the 3 day. 7 errors.
Sexual abuse. Definition of sex.
It's a small bag. So small and related. Whoever with sexual intent touches the soil. Okay. So what Lordship has said, he said sexual assault को definition चाहिँ 7 मा छ. 3 मा पनि त्यहीबाट definition तान्नु पर्छ भन्छ because it says penetrative sexual assault. So that's why intent is required. In a case where I will ask you about East के हो गरे पहिला कस्तो लाग्छ. There is a lady who was the accused and female victim. She put soap in her vagina.
Yes, I have heard.
We have not done that case.
I have not done that case, but this was.
Person got
this was
acquitted in
relied on.
POCSO. What's your view? The court reached a conclusion. Trial court had convicted. Court reached a conclusion, the Honorable High Court, that she was actually torturing and had no sexual intent. What's your view? Just a discussion.
Mostly I feel that the sexual intent was not there. Because she was that was not only there were many other tortures that she was meting on the victim. So I think it was in that process, if you take it in totality, it would also come. I felt like that in my opinion. They would say torture, it was a form of torture, not of sexual intent, or else she would have resorted to it in previous occasions. I think there was only one time when she had done that. So if it had been a series of her doing the same act, then maybe sexual intent would have been, we could make out the sexual intent. But
Okay, if the accused was male?
If it was male, then I think another.
Let's look at the pure object of the act. No, you are relying on the act.
And that
So
women.
we are just replacing the accused with men. So would you still say what you said just now?
No, I would not.
This is a
Because.
male and subject is different. Subject is actually different.
No, the facts are remaining the same.
Female also can do the sexual
I'm just
assault.
replacing the person out there. Why a man cannot torture that way? The moment man is brought, the very act of putting soap in the vagina, why it is considered sexual intent and not with a woman? A woman.
I don't know for the
Yeah,
reasons, but
We have to
I'm a
take a
female.
study. It is like our society may be like female, they
Maybe we
have.
have been
Let's
brought.
forget everything. You are as a prosecutor, there I am as a judge. If I think, oh, this society says that, then I am making wrong decisions. I'm saying, let's replace the exact fact the accused to be a man. Would it could have been still be said, oh, it's a torture, I don't know. But would anything have changed? Because I see that sexual intent does not only mean having sexual intercourse, having sexual feeling. You can torture sexually also.
Yes.
I would have convicted. I feel that. Because if they give that leeway, and now if the man is replaced, then the judge see, oh, this is a man, he did it out there. I cannot assume that. I should not assume that. Probably I may be tempted to do so. But I think if it was a man, you would have definitely convicted with all these facts. Otherwise, even the woman could have put in somewhere else. So why she is putting there? I need the answer to the question. Why she is putting there? I need that answer. Why not anywhere else? She got some kind of gratification in torturing that. Kind of sexual gratification. But in torture also. Even in the Nirbhaya case. Then they were torturing, no? Forget it. Why you consider it a sexual assault? You were torturing it with all those rods. It was a pure torture. whoever insults. With all due respect, I would have convicted them on the POCSO. She had no right to put anything in the
Yes,
vagina as per POCSO. Anything. Whatever her intent is. And deriving sexual intent from section 7 also I find it wrong. Because nowadays you are not putting sexual intent. You are not required to. You are only required to do penetration. Otherwise you will have one more burden of proving intent by all other acts. Only thing it saves an accused out here is culpable mental state.
Yes.
And in that case, the victim, the accused had not taken a defense of culpable mental state. It's her burden. Why should the court look whether she has sexual intent or not? It's her burden to say I had no sexual intent. So I most respectfully disagree with that judgment. Any other thing? Okay, let's talk this way. We will break for a while for because to make this topic is not that well given. Because even if there are bottlenecks, what we have to do with this? We cannot change the legislature. And if anything, for a seminar, etc., this topic would have been very good. With large audiences. But working on practical aspects in the court, this topic is too big to be covered in a program like this, where I may not be knowing everything, you all may not be knowing everything. We need a large audience for this topic, who can give all their inputs. And from different fields. I am a judge, you are a prosecutor. We have our own perspective of looking at things. So somewhere it may match, somewhere there disagree. So we'll move like this only, whatever discussions
So what I feel is like POCSO everybody thinks like it's a very complicated POCSO case. Oh my goodness, so but I feel it's very simple.
It's simple. In fact, sessions trial are more simple than magistrate trials.
I feel that.
अलिक लेन्दी चाहिँ हुन्छ कि
Lengthy हुन्छ.
इन्ग्रिडियन्ट्स पुरा कम्ती हुन्छ सेसन्स ट्रायल इन magistrate trial case there are in one section there are 5 or 6 ingredients and forgeryहरू गयो भने त 8-9 वटा छ सबै प्रुभ गर्नु
They have to prove the offense, the culpable mental state, then the minority that the victim. Firstly, you have to prove that she is a minor monthly the offense part. So I think that's the main.
Yes. Then the burden shifts to the defense now. 27, 28 if you cover, then burden shifts to the
it is minor
defense.
thing. I remember one more judgment which was accredited, in many cases accredited because age is not proved. Now what if the child, because there are certain standards, the age is not proved, if the Liana, school register Liana, and then what about someone who has not gone to school at all? Right? Okay, we cannot bring something from school now. Next thing is, what if the child is about 2 or 3 years? A birth certificate को तपाईं हेर्नुस् कि जजमेन्टहरु ठुलो केटीहरु भएछ 14, 15, 12 actually. But what if someone is now on that one, okay, 15, 16 हरुमा birth certificate prove गर्न सकेन but what if it's a 3 years old and we go by that standard and the judge is seeing the child is 3 years old?
Yes.
What to do?
You see that I think that is all part of argument also we should bring forth that it has been observed by the honorable court and he has seen that it is merely an infant mother already to know what if that
That's
is,
right.
we can also
Court
Now
observes
if you
that.
go by that standard, no, there is judgment, no. Age proof matter. Whether it's 3 years old or 17 years old something, the evidential criteria जुन चाहिँ prescribe गर्दैछ जजमेन्टले त्यो त चेन्ज हुन सक्दैन. Now the judge will have to write something new to overcome that. I have seen पनि अब judge cannot be a judge himself actually. Actually that observation should not be an evidence. Evidence मा त आएन नि त जजले आफ्नो observation लेख्छ.
It's observation only.
Why should be?
but we as a prosecutor
That's the only way out. That's the only way. Judge has to observe. अर्को बाटै छैन.
we have to put forth that.
अब 17, 16 को त एज प्रुफ भएन भनेर छोड्दा पनि ठिक छ. अब त्यो
So
देखिरहेको छ नानी. अब 17, 18 त जजले छुटाउन सकेन ठिकै छ हैन. देखिरहेको छ नानी कसरी चाहिँ जजमेन्ट लेख्नु कि एज प्रुफ भएन. Obviously if nothing has been brought in evidence then that's a different matter. I have to review.
नानीहरू भन्ने पनि होइन त्यहाँ सिमिलर केस नाम्चीमा पनि भइरहेको छ 3 साल वर्ष नानी के भन्दा के पोलिटिक्स पनि गर्नु सक्दैन भन्नु पनि सक्दैन.
बोल्नै सक्दैन.
So also one thing I was quite disappointed and what has been laid down as per section 12 earlier in GG Act regarding the determination of the age for mentioned that you have to bring the school records of the first school attended.
See,
It was
do
there.
you rely on JJ Act to prove the age of the victim in some cases?
Yes.
I would reject it.
Then,
No, I would not allow JJ Act.
Yes, yes.
I bring JJ Act. I'll show you one. Change, no? There is a High Court judgment also. No?
there is Supreme Court judgment also.
Yes, yes.
Done and since.
Yes, and after that High Court judgment we have our High Court.
No.
It is there.
Then,
But I would say no, that cannot be done. Journalism judgment is over now. You may understand.
anything,
I'll show you
anything,
just
anything
why.
with why it cannot be like we cannot resort to that
Well,
journalism.
that's what they are going to say. You cannot resort. You may understand. Despite that Supreme Court judgment. I have my own reasons. Maybe it
There is
can
a
be
High Court-
countenanced.
There is a High Court.
High Court judgment is
also
there.
that effect.
It says JJ Act has to be followed.
Yes.
Oh, yes, yes.
That is
yes.
in consonance with Supreme Court judgment.
No, I think that is like Vinay Tamam or something like that. I think
Could be,
so.
could be.
Vinay Tamam, but still that's the one.
But I would say no. If I am a judge, I would say no. Well, let's not go by that standard, I would say. You can bring it, but not JJ Act. Let's not follow JJ Act. But you can bring it anyway to my understanding this COT. So
So
let
this is an alternative way to rely.
the parent come. Anything that can prove the birth.
If the Boxer Act is not sufficient, then we can do.
See, JJ Act, why, if you do not follow JJ Act in victim, and victim's case, and you have proved the birth certificate without that criteria, is it wrong?
No, it is.
No, it is not. The judgments are only saying, you can do this. It is not mandatory. No? For JJ, for POXO cases, for JJ it is mandatory. You have to follow that line.
But so this company, like now section 94 is in play, always section 94 is there, which says like, this was the first school attendant has been, it's struck down, it's not no longer there now. It's just like the school
Matriculation.
attendant,
Okay.
the school attendant, or matriculation.
I have not noted that.
Matriculation certificate, school attendant, or the first school saying, school attendant one, and it is a difference always takes that we must saying
Yeah,
that
first school.
On the play school or like on.
Play school is not.
Vinay Bandhu, right?
Vinay Tamam is still like some all is confused, right? Like so many different. Leadership has given. Most probably it has to be Vinay Tamam is still like.
Current counsel for the appealant submitted that the prosecution has not attempted to produce the birth certificate or school records to establish arrest through documentary evidence, and therefore the prosecution has failed to follow the law declared by the Supreme Court in so and so. The judgment in the Supreme Court in both the cases examined Juvenile Justice Care and Protection of Children Act. Which year? 2000. Okay. And Juvenile Justice Care and Protection of Children Rules 2007. I think, right, you didn't get a word what I said. Juvenile Justice Act of their act. Thank you. I was wrong. Came into force into 2009, repealing the Juvenile Justice Care and Protection 2007, Juvenile Justice Care and 15 repealing Act 2000 came into force in so and so. Prosecution has not followed the laid down, procedural laid down, that is ascertain the age of child by adopting the method postulated in Rule 12.3 of the 2007 rules. Had the learned special judge followed the special procedure laid therein, would be certainty and definiteness in ascertainment of the age of the victim. The question is, if therefore as submitted by the learned counsel for the procedure laid down in the Supreme Court has not been followed, what is the evidentiary value of the deposing father and the victim regarding the case? So even here the court is saying yes, the judge should have followed JJ Act. Okay. Yes, but now JJ Act 2000, so it's there. Journal Singh judgment is based on JJ Act 2000. Let's not go by that. Now, there has been one change in 2015 and so 94. Which no one has noted to it. Now that procedure what Supreme Court, even in Journal Singh, it's not mandatory, that you go by that for victims. Otherwise, your case will fail if you consider that to be mandated. Presumption and determination of age. Now, similar provision has come in 2015. Also, Journal Singh said in 2000, yes, you can do that. In fact, it's better if you go by that, right? And those cases said in the context, where some kind of matriculation were bought, and the defense was challenging, no, birth certificate is not bought. Supreme Court said there's a procedural laid down in there. You can adopt that. There's nothing wrong with it. In that context, this has been said, not saying, no, you follow that. JSM has we have to follow this. Where it is obvious to the committee or the board, based on the appearance of the person brought before it under any of the provisions of this act. Now can POCSO court say, as we are saying, observe and say, oh, person hasn't got before it looks sad. Cannot say. Where it is obvious to the committee or the board, based on the appearance of the person brought before it under any of the provisions of this act, other than for the purpose of giving evidence. Finished. Journal Singh 2000 Act are all over. The bracket it says, other than for the purpose of giving evidence. So it is, whenever someone is coming to give evidence, forget about victim, it could be anyone, a child. You cannot use this section to matter. You can do things what is out here, but you cannot say, no, I am relying on JJ Act and doing this. That the said person is a child, the committee or the board shall record such observations stating the age of the child as nearly as may be and proceed with the inquiry under section 14 or section 36 as a case may be. Now when does the subsection 2, when do board or committee in JJ goes to determine the age? Only when they have doubt. POCSO court can do this, they need proof.
Yes.
In all cases, it has to be.
Right. Yes, what is written there can be done. But it is not that, you bring birth certificate and the defense saying, no, you should have followed this. So what I would say? I just need, POCSO court needs a proof of age, an accepted proof of age, that's all. Now this does not say age of parents. POCSO court is. So anyone, brought for giving evidence, proof of age must be there. You cannot rely on this one. So, journals, see, once the legislation changed, when Journal Singh's judgment was this bracket portion was not there. Anyone, evidence to, okay, the exception got this evidence there. So I would say no, it's not true.
After the amendment, things have changed. Then
Things have changed.
we cannot rely on Journal Singh totally.
No, it can be taken as a guidance,
Just
but it is no longer a precedent after this act, to my understanding. Okay? What does the defense say? You did not follow this.
The defense, what they say, they go by it only. They go by section 94.
Forget
So
it.
they're saying like, not even section 94, they're going by section 12.
Forget it. 12 is no more required.
12,
No more.
they are asking for
Non-existent.
documents from the first school attended,
Forget it.
the first school attended, admission register and all, they go
No,
by that.
see, the whole perspective, they can always say, well, your birth certificate which you have brought is not reliable. Okay, if it's absolutely reliable, then asking for that is pointless. So you got that point.
And the IOs
Except
seem
for
to,
giving evidence.
IOs seem to now think that you have to put everything. You have to put actually it's either
Not
or.
everything.
You don't need to put the school admission, your record, saying then again birth certificate.
That's what,
It's
they are
not-
working blindly. No, see, if in the school records I get one date of birth, if in the class 12 I am getting something else, in the birth certificate I am getting something. Now as a IO, which one to rely, I do not know. I have to find out the truth, which is the exact age. Okay, then I have to search. Now poor police does it. त्यो झाडुले बटुले हाल्यो.
Just for the sake
You have think I don't think it.
no, they have just heard that.
His only conclusion offense has been committed.
They just
It's
now know
because of-
that you have to put. So I'll put everything.
Everything
For the
and
same
submit
time,
it
they
to
put other documents, then it becomes a difficulty for us to prove.
Defense
because of
escape
the-
advantage things.
Are you
What
think-
can you do?
are
Also,
you
now
think
you
that-
have been given 3 things. You also don't know which is the correct one. Now you have to say to the court that you also are left with no option. You will try to exhibit all 3.
And they
How it
are,
comes to
they
court,
are,
what will
they
be?
are also going by the rule 12.
But how does Rule 12 exist today? It doesn't exist.
No, it doesn't.
Because
That's
they
the
are-
judgment being said on Rule 12. It's no more existed. Forget about that judgment. It doesn't work. You can take it as a guidance in, deciding another case. Honorable Supreme Court have said this. So I would also do this even under these rules. Provisions are similar. But I said one exception is there, except for other forgiving evidence.
That's what I don't understand. Why times of filing the birth certificate also school board ने report में हालेर it's a separate.
School हाल्यो भने परेन.
स्कुलमा काम बटुले हालिदियो अनि सक्यो जेसुकै होस् कोर्टमा ल केही मतलब
Actually, major bottleneck matter, one of the main thing is faulty charge sheets.
Yeah.
That is the main thing because we as a prosecutor, we cannot do anything once the charge sheet comes to us. We cannot make changes there. Whatever they file, they are given the charge sheet. This way we have to go. We cannot go beyond that.
And they are thinking now of bringing Directorate of Prosecution. We're all very useful. What's the use?
And I believe, I don't know what is. We received a phone call from them saying we are calling from Directorate of Prosecution and the AD speaking, and they have already established it. Seems,
Okay.
I don't know that nothing is there on paper.
There is no limited things come law. I don't know, you all must be united. Don't walk down there.
And-
If there is something
and
wrong, you go and
they-
straight away meet the head
I
of the
think the
government.
Directorate
And
of
this is the
Prosecution-
problem. We want to do good cases.
And if
No,
this
it's not.
Directorate of Prosecution comes, I believe, I've just heard that they are saying they are not okay with us absorbing us or something. They just want us to be on a higher and higher basis. We want prosecutors, but we just want to, they'll come, we'll have them, then we'll fire them. So they're not looking out for our interest also, I
Yeah,
believe.
Some of retired person will come, some known people will come up. See, if I would have been in law department, I would have never allowed this to happen. At least I would have put my biggest, at least I would have recorded my discontent. Whether you amend it or not,
actually we
that's
have-
Home Department's thing.
Actually, we have filed an application for regularization of all the PPs and requesting the government to make a state prosecution cadre so that they regularize us in that cadre, state prosecution cadre गर्दै चाहिँ त्यहाँनिर गर्नु भनेर चाहिँ we have made a
I have
proposition to the
just
government and they are also quite hopeful for that because if we are going to, now we are working duita post we are working as a government advocate and also as a public prosecutor. But once DIP appoints us, then we will be just public prosecutors. Then the state would again have to appoint us as
Civil
government.
cases for civil cases.
So that would be a burden over the state.
The SIs know more law than the SPs or DGPs or AGPs, whoever is there. And once things happen, things have to be done when it has to be done. Once one charge sheet came, all facts different. Conclusion part was copy paste section. The different sections not matching the defense. How will I take cognizance? Fact says something else. I has put something else. That was too much. When I called the court inspector and said, see, it's my order. I will not touch this charge sheet. You return it to the same route it came. And it went back and afterwards they corrected it and it ultimately went to the IO. Corrected it. SPs are not reading it. DSPs are not reading it. No one is reading it.
That is very
So-
surprising.
So think a directorate prosecution consisting of these people, will it improve?
That's
No, they are not going to read it.
the
Even if they read it, they are not
essence,
going to
the
understand it.
very essence of the Directorate of Prosecution being coming to play the judgments of the Honorable Supreme Court, making it mandatory for the states to establish a Directorate of Prosecution. The very essence
No.
of it is not being put to use. I feel if
The
they.
person who asked me for opinion, I won't take the name. Today I regret of saying one. I had said him, see, don't do this. But if you really want to do it, then you have to amend this here. And that fellow got that point and said to the government, we have to amend the CRPC to get your things done. Could not have been said. It
But
did not
unless
put
and
for the
until
other
it is-
opinion.
So
Why it is wrong?
unless and until it is amended, they cannot do that because they had already made one person a director, and again they pulled it back. I
No,
think.
no, how can they do that?
Then no, it's like this. No director.
Okay, if these people call you and go,
Then-
take the charge sheet and explain in all legal things. If the fellow doesn't understand, say sorry. I do not know, I cannot work with that.
No,
But that's what your position is, you have your job also. No? And all these people who will be appointed will be having some things, and you said something, Jyoti said something, not a good prosecutor. The director of prosecution, I know, 50% changes improve, if there are lawyers there.
because so the CRPC is so clear about it that
That's
in the
director
post of the
has to be-
director, an advocate having 10 years of experience has to be there, and even for the purpose of deputy directors.
Yes, yes.
Deputy directors for.
In that sense, I thought as a director, some
Actually,
assistant
we,
director, lawyers are there,
lawyers are-
and things, because I've seen in court how things work.
This I think we should take up this cause. Thanks to sir, I think we should take up this cause and approach the bar association of Sikkim and tell them to intervene in this cause. And
Of
go on for it.
Why should a lawyer not be there?
They have to
We
be-
have at least, we have qualified lawyers out here, I mean 10 years, who can become a director. I have seen that much.
Really, not only that, sir, director, deputy director.
No, only for the lawyers.
To hire
Now they
people,
don't want to be below the lawyers.
They are saying
That's the
like,
problem.
on the one side, they are saying like, we'll put them, but we won't absorb them nothing. We'll just hire and fire them. These prosecutors will just hire and fire them. That's what they are speaking. They are saying right now. So
No,
like
no, in
this,
that case, let them vet the charge sheet. Let them find out the loopholes. Now what presently police does? They have a checklist. They hire SPs, DSPs over there. 164 gare. Arrest kati gare. Now the police are very happy if they get accused arrested and sent to JC. Conviction not required. It's not required. JC चाहिँ पुग्नुपर्छ. Arrest चाहिँ हुनुपर्छ.
and the sir ne bhannu bhako, one more thing I really, it really has to be put to use. But sir said like you all only arresting and like arrest bhako, case bhako. There's nothing in social media, nothing as to how many
Now,
convictions are
I
there.
still
and
remember
all.
that Pathan case, no? My courtroom, this district court was full of people. The court was my courtroom was full of people, including all court staff also there. What will happen now? To see that? Such a thing they did. Even the media would blame. They follow up what happened to the case. Now tell the society the fellow got acquitted. And he has a right to be, he also has a right, whether rightly or false, wrongly, I would say rightly acquitted. Because if I speak legally, whatever be the facts, okay? That fellow had a right to be said to this society that I was innocent.
Oh, yeah,
That will bring
justice-
down the police's.
No, really, so the people are questioning the criminal justice system of Sikkim. Because now they are saying, what are these people doing? They'll come and we'll do justice to them, we'll bang them, we'll eat them. That's what is happening. They have lost faith in the criminal justice system. The Sikkim, that case was all highlighted. Now what happens? A few days later, the case will come. Maybe it will get convicted, maybe it will get acquitted, but nothing is brought up.
Probably it will get acquitted because it's only the media person that is the accused. How do the hell we know he is the accused?
So it's
They're saying
like
confession. Confession can be. If confession was so valuable, I know it is no conviction. Then
that's I
confession.
blame the media also here, sir, because they are very weak. Because they at least follow up the cases. Dr. Sanjay ko case ma came this. So come follow up what is happening.
Which are number and conviction of it there.
Also,
And tell the society, no convicted.
they will go on
And give the reasons
giving
why.
all, they'll go on giving all the news and like what is happening because in our court now, Pokso court, we had this month I think we had more than 10 convictions. So nobody is coming and saying like Pokso at least the outside people will also know that if you do this, these people are going for 20 years. 30 years, and let the people know not for us to get highlighted and everything.
I feel sometimes, the mob which was there in court or wherever it is, of course the family members are worried and deeply sad. They have lost the chief child. But the remaining men, etc., and I would say that they are more potential rapists. Just there, out of nothing to show solidarity or something. These are potential rapists to my understanding. A genuine person would not protest that. unless you are immediate family member and hurt very much. I know. A real civil person, unless you push to a certain extent where you have a personal loss, etc., why would that person go and bang the doors and vehicles and some extra person? Those are all extra people, some from political side. And I saw in that fellow, poor fellow, that lawyer. I don't know whether he was coincidentally there or in.
No, actually, he invited that trouble on himself.
Okay.
If I may say so. Because he was, I believe, he was having lunch and he was coming, he saw the mob and he's always there.
Yeah.
Then he came running down and he got the trouble, whatever he had come looking for. I know what it was, he ran around about.
So it was that also. Why would immediate relative like पुरा रिस उठेको हुन्छ र तोडफोड गर्छ हस्पिटलमा गर्छ टाढोको मान्छेलाई त तोडफोड गर्छ unless you have some other intent, you are part of that and just faking it out. Okay, we'll break for 15 minutes. What time is the lunch?
1:30.
And by schedule do my program. That's all. We'll break by 2. Oh, it's 1:30. Magistrate court मा त पुरै आउँछ कि सेसन्स कोर्टमा कति
सेसन कोर्टमा त्यस्तो बेसी नहोस् इलेक्ट्रोनिक
सीसीटीभी को लागि
सीसीटीभी त्यही हो
There is no draft fund to get appointment. No, 65 draft fund is अलगै हुन्छ सबै
कस्तो ड्राफ्ट
No, one draft fund को policy त्यहाँ पुरा गर्दैछ त्यो
के हुन्छ छैन
स्टेटमा बनाउँदा
हैन
हैन
सीसीटीभी इलेक्ट्रोनिक
इलेक्ट्रोनिक एभिडेन्स हो इलेक्ट्रोनिक एभिडेन्स
ड्राफ्टम्यानको कहाँ छ हेरौँ न भन्नु कुन चाहिँ सेक्सन हो
त्यो त 65
अझ सुनेको थिएन
एभिडेन्स चाहिँ 65 B मा
65 with electronic evidence.
इलेक्ट्रोनिक एभिडेन्समा त्यो सर्टिफिकेट दिनु पर्यो
हैन उहाँले चाहिँ जुन चाहिँ त्यो
ओ सर्टिफिकेट
रफ स्केच म्यापको कुरा गरेको
हजुर।
Obviously रफ स्केच म्याप I never looked at I like throwing in the dustbin because it's a rough भ्यालु न रफ
हेर्नु नि एक्जिक्युट गरेर के फाइदा छ
हैन त्यो रफ स्केच नगर्नुहोस् न एउटा बढ्छ भन्थे गर्नुपर्छ नि सर you know the mask is गर्नुपर्छ नि सर and sometimes when she was in pressure and then legally something has come out action किन हुँदैन त्यस्तो भनेर हुन्छ and she was under pressure in some cases obviously BBs are under pressure in some cases and the जबरजस्ती she used to put it in action 65B encounter हुन्छ CCTV मा त हुनु पर्ने
Yes, we have माथि because अहिले चाहिँ what is there is भने हाम्रो जुन चाहिँ the electronic evidence because you sent mobile for
now lots of electronic evidence will come
extraction of data, then they send you the extracted form of the data. And because what they do is like they extract the data and put it in a pen drive and send it. But मेरो जुनै एउटा केसमा चाहिँ the expert did not give his 65B. He has to give that certificate because now the 65B is clear that you cannot. Now, with regard to the pen drive also he has to give.
of course
Because now that is not, we examine the expert and then we find that.
why did the court examine the expert I don't understand
With regard to the three evidence.
there was no 65
There was no 65.
why to examine the expert it's wastage of time for the court also
We did it and at the end there was no.
what will the court say in the end no 65B it's a section of admissibility if there is no 65B there is no question of exhibiting it whatever even if the CCTV is there
Yes.
the judge should not do this if I have the defense I would have vehemently
The
objected
defense also did not raise any objection as such. That we
Okay.
went ahead and we examined the then we find that there is no 65B.
how can you examine let's say how can you examine an evidence which is not admissible at all no matter what relevancy it contains I cannot see it as a judge
But there have been
And this has-
instances where the expert sends the 65B is there. So
okay yeah in that case you have to examine but I think it's wastage of time if 65B is not there and the judge is looking into the CCTVs, calling the expert, etc. It's all wastage of time. Your base is not there. What will you do with the tower of them?
it becomes a futile exercise at the end.
It's waste of time. It's illegal also for a court to view that whatever is there. If there is no 65, cannot. It might influence your right. So now after that Arjun Pandit Rao judgment.
100%.
Now, to my understanding, this 65P is a major bottleneck. It allows things, but very restrictively, right? Now, there's a lot of criticism. This is borrowed from some 1990 or 1999 somewhere, some British legislation was there, borrowed from there. So I have read that legislation also, but I don't remember the year. Now, things have moved ahead, we are not moving ahead. I would believe there was an opportunity to, make this section by judicial pronouncement more easier one. But I do not know in this section, all the interpretations that have come has been very strict. I do not know the reason why, okay. Now if you see this section, when it came in 2000, when IT Act was made, inserted by 21 of 2000 Act. Now in 2000, there were no extensive use, forget about CCTV. The legislators, to my belief, had nothing in mind about CCTV. They were only thinking about computer when this section was brought into force. In 2000, computer had come into our country, and there was in many places, computer was being used. It was one of the biggest electronic thing that the country was using. Forget about mobile, there was no mobile, except a few privileged ones maybe. CCTV, when you forget it, it was there in some major offices and nowhere else. And all other forms of electronic pen drive, etc., it was there. Because of that, now this section says one thing. Okay? Who gives the certificate? Who gives the certificate? In any proceeding where it is desired to give a statement and evidence by virtue of this section, a certificate doing any of the following things that it say. This is 4. Okay, and it's not just 4, okay, it has to comply with all these 2, 3 also. And purporting to be, who signs the certificate? And purporting, okay, to be signed by a person occupying a responsible official position in relation to the operation of the relevant device or the management of the relevant activities, whichever is appropriate, shall be evidence of any matter. Now it says responsible official position. Obviously it says so because the computers were there in offices or in those times, or banks, whatever it is. Who thought that PC would be so common in homes also? Who thought that CCTV would be so common in homes, streets also? Now in this case, where is the question of official position? If I have a CCTV at my home, I do not own any official position of that. I may be the head of the family, but I am not owning any official. So this section never contemplated these things, but it has been used for. Obviously, that 65B type of section must be there for electronic evidence. Now, why do you think? See, I can forge this document equally well, but there is no such certificate required for these physical documents. Why do you think it is required for electronic evidence? What could be the reason? I can forge this also and present it to the court. There is a doubt that electronic evidence would be false.
It's morphed or something.
Yeah, because electronic evidence is such a kind, anyone, anywhere can forge it easily. The potential of forging electronic records is very high compared to physical records. If I have to sign something here, let's say I have to sign Mr. N.G. Sharma, okay, this is there, myself. I can sign this after about 2 or 3 practice, but it won't be exact. The eyes will doubt it, but in electronic, I can produce exact NG. Exact NG. That is why electronic evidence are not trusted. So that's why this section came. And then it says official position which did not contemplate all this. Now in CCTV, who should give this certificate, right? Now what usually police does is whoever extracts it, so the computer shop, etc., and he's entered it. In fact, they have no stock witnesses of this. He will come and he is also used to it and he will try the best not to lie. And they are experts also. So now, if it's of my house, okay, I am the owner, it's under my control. Now, the situation came when police found that owner doesn't know anything about that CCTV, he just installed it. Someone else maintains it, the shopkeeper, whoever sold it. Now, the police thought rightfully, now he is the one who should give certificate, rightfully, because it was under. Actually, it was not under his control also. It does not completely meet this section, but he was someone who was dealing with it who could say something about that instead of the owner. Owner could be some illiterate also. He doesn't know anything about computer. So those people are coming. But if given strict standard, then I wouldn't think that person also would pass the test of giving the certificate. Because he usually comes sometimes and whenever it's not working, he maintains it. He does not have knowledge of regular working of the CCTV, which is a requirement of this section. When you are now just this technicality of this section, only computer expert can give this certificate to my understanding. The conditions referred to in subsection 1 in respect of so and so shall be the following, namely the computer output containing the information was produced by the computer during the period over which the computer was regularly used. Now this can only be done by a person who has the regular monitoring of that device. Right? Once you put CCTV and forget it, you even don't know when it stopped working. Only when you realize that you call someone to do it. Okay, work for it. It's just by a combination of computers operating over that period, by different computers operating in succession, so and so many things. Giving such particulars of any device involved in the production of that electronic, to me it's absurd. The only purpose this section is there, what purpose does this section 65B does? Does it avoid forgery or tampering of evidence? No. The person who gives certificate, the only role here is, if he lies, he'll be responsible. He can lie also. Usually they are like, they don't know anything about computer, what happened out there. Okay. So the only purpose to my understanding this section serves is, it gives a little bit of assurance to the court by looking at this document, certificate, that it is genuine. It may not be genuine. Its genuineness has to be tested more in evidence. The certificate just lets the evidence get inside. Admissible subordinate, sir. The contents of its proof are different. Does it prove different? Merely because CCTV is produced, 65B is there, the contents therein are proved, it's not true. It just makes it admissible. That's the only purpose this serves, and as I said, some kind of reliability comes in when someone is giving certificate. But I was doing one case in 65B, the whole 65B would fall. If you tell defense this question, 65B is gone. Usually you get that very answer. When the person who gives the answer, he is asked one question by defense. Do you know what is written inside? He says, I don't know. What's the value of certificate? He doesn't know anything what is written. Gone. Admissible the buying certificate. But that genuineness and reliability of okay, it can still be proved the contents. But can I let the contents to be proved and rely on it when the person who gave the certificate is saying, I don't know anything what is written inside? Very admissibility is dented. Then there's no point in looking at it to my understanding. So after that, I always wished you, defense should ask that question, so I'll have work less of studying that whole thing. In only one case, one lawyer has asked that. So after that, even I got, oh God, such a big certificate, and the person said he doesn't know anything what is written there. And that's a very requirement of this section, that the person who gives this certificate must know what is there inside it. If he doesn't know, then what's the point of it? Okay. So this is a major bottleneck in there. I don't know how this will be overcome in future, because a lot of electronic evidences will come. In fact, we are adding very little electronic evidence compared to what it actually should come. If police were tech savvy and would be using scientific instruments, we would be adding a lot of electronic evidence, which is not there. Now, another funny thing in this one is, let's say this is a camera, okay? If you bring this original to the court, is 65B required?
It is an electronic.
No, let's say this is my mobile. No, this is my mobile. And if original is brought in the court, there are some recordings out here. This original recording is tendered in the court. Is 65B required? No. It's not required. 65B is only required for secondary evidence. Okay. When you are tendering secondary evidence as against the original.
But even in the mobile phone, the content may have been forged. No?
Yeah.
There are so.
It could be. That's why I'm telling you. No. So what purpose does it serve? It only makes the court a little bit of belief that maybe it could be genuine. It only allows things to be placed before the court. That's why I said a judge or the court recording evidence to the electronic records, whichever has been brought, without 65B is a wastage of time, should not be done, it's illegal. Okay. Now, if original is brought, not required. Now, where does our actually usually the data remains in phone? Where it is remain? In memory. In the memory card, even this has memory card. Of course, it has its own memory, but usually all our recording, etc., goes to the memory card by default. Now, the moment you take out the memory card from there, as you said, pen drive, 65B has to be given. Now, I asked a question, what's the difference? Is the very memory there, put in the original device and I'm bringing, you are accepting it without 65B. Now, even in courtroom itself, okay, I won't give my mobile, I'm taking out this memory card. It's here actually. They'll ask for 65B. I don't understand this. It's because of the interpretation, it has become like this. The moment you take out this memory from there, you have to give 65B because it becomes secondary. Otherwise, very that memory when inside there, from there on you are looking at it, it's still called primary and the 65B is not required. So it's with flaws. To my understanding, it's not a single purpose apart from making that electronic evidence admissible. Then if it's so, leave it, no, let it be admissible, otherwise also we test it during the trial. So it's a bottleneck. I don't know, a lot of seminars, conferences are being done under the 65B, but no way out has been found as to whether to keep this section or to remove it or make something better, and remove all these words official and don't make these complicated. Let it be a simple certificate. No? It's my device. I know it was working properly. To the best of my knowledge, no one has tampered it so far. That's insufficient. Why do you have to make it so technical for a common person to give that certificate? You can keep it for official, all this record. But for common man, make it, it was in my house. I installed it with the help of so and so, and to the best of my knowledge, no one has tampered it. It would serve the purpose of admissibility. If that is even if the person says, I do not know the content, it's still safe. If you ask the person who gave the certificate, a common man who had certificate is all these technical things to be said, he will obviously say, I don't know. Right? So these are the problem in 65B. Another one. Okay, let's charge sheet. I think you all are very well aware that even after filing of charge sheet, the police can still investigate the case and bring the evidence and put it under 173(8). So they usually do not do that. Most of the police officers do not know, they get the evidence later on. They can still come. Some have the concept of supplementary charge sheet, but they do not understand that by supplementary charge sheet, they only understand I can put it later on. They do not understand they can still continue investigation, and if they find something, they can. आजकल supplementary charge sheet तब मात्रै हाल्छ पुलिसले जब उनीहरुको काम सक्दैन हैन फर्स्टको अलिकति दिन्छ बादको लागि मात्रै गर्छ. But supplementary charge sheets are actually meant to be, some things are still remaining, things which are very substantial, and I want to do it. Again, with the court's permission is also not required to file 173(8) charge sheet can be registered in the CIS, brought to the court will have to accept it. There is no way. So they don't understand this. Okay. Another thing is, what could be? In my court, I did not see much bottlenecks for the prosecution.
Then there are seizure witnesses who, the police make seizure witnesses and they come and they are also not read and they are not explained properly as to the. That is a big hindrance for the prosecution. The witness come and they say I don't know what this paper is.
Yeah,
They didn't show it to me. They didn't say from whom it was seized.
Okay, if it's drugs cases where witnesses examination of bodily search before a gathered officer or a magistrate, like customs cases, NDPS, is mandatory. Their seizure witnesses are absolutely required. But do you think seizure witnesses are required everywhere? I don't think so.
With regard to POCSO cases in terms of birth certificate and all, it is required.
No, I don't think. Even I have got a reservation in that because seizing the birth certificate is original. It is like the minus birth certificate. So seizing I don't think it will hamper the entire prosecution. I
But
don't
that chain also is broken as
See.
to from where the birth certificate landed in the charge sheet.
Okay, absolutely. Absolutely what you are saying. If you are seized it, it's all right, okay? That's a procedure which you follow. But when do you seize things? From my understanding, when do you seize? When someone is not giving you.
Yes, yes.
Right?
Birth certificate is handed over.
Is collection of evidence and seizing of evidence same thing? Now, let's say, what example could I give? I would say collection of evidence is very much different than seizing. Seizing has a, from where do you derive the power to seize things? No? Section 100 is there one. It talks about closed places. That means a house where you enter. Definitely requires seizure witnesses. It says two respectable persons of the locality when you are searching the house and taking out this thing. Now, obviously, if someone is coming and giving you birth certificate,
Sending take.
it's a collection of evidence. Where do you have to seize it? I don't understand that. Because this has been, this has been the procedure since long time. It has been followed what was there. As I said, give the truth. Why would the court disbelieve an IO saying, I went to the house, the father gave me this birth certificate? Why would the court disbelieve? I don't know, sir. Is IO's evidence less valued than of an other witness? No? If you can prove the truth, I don't see any disbelief in that. Now, every little things are seized to understand. And when what seizes, then police seize all those things are irrelevant also. Whatever is found in his pocket. POXO office to paisa kina seize garu?
Yes.
Unless it has some bearing upon the case. Right? And so many things, wallet, shoes, everything, whatever it was, wearing chains, etc. Gold chains.
And it is not mentioned in the
And you know, in this context, I'm telling you something. See, I'm not saying what the person said, all can lie, okay? I've had two instances where whose things, gold things were seized, came to me and complained, the police did not return. And I said, okay, then let me see the seizure bill. It's not mentioned there. And the fellow said, yeah, it's not written out here, okay, now I can't help you on this. Unless you give me an elaborate petition, challenging it, then only I can do it. Or a simply release petition. When it's not there in the seizure, I can. But the fellow cried before me, and he was someone from outside our state. Said, so I still even phone. I know that the person I had rings on my finger. They had asked me to take it out in custody, and I had given it to them. Even the moment now, when I'm going to police station, they are saying we don't have. Okay, so we should not accuse someone without any solid basis. But things as this does not happen in Sikkim, I don't believe. Why to believe? Do we have gods in our state? Everyone working properly? No, I don't know. Somewhere here or there, these instances might be there. So Caesar is very, very relevant in these things. So police are seizing everything. A fellow wearing a ring taken, it's not mentioned in. And I called the SHO. Person named who had taken it from. Called him, he says, no, I didn't take it. Now whom to believe? Unless I have evidence. Right? But I felt the person is not. Why would he come from far away place after getting acquitted and say, see, my things were here, I want to take it. Why would he say? Not say. So I believed him. Either it's lost or it's somewhere. And see, search. Police usually use section 102. Search is the 102. And let me tell you, any police officer may seize any property which may be alleged as suspected to have been stolen, or which may be found under circumstances which create suspicion of the commission of crime. Now this section nowhere talks about witness. Okay. Now my thing is, if you, now there's an FIR, let's say a murder, it's endorsed to IO. IO goes to the place of occurrence. Right? And he goes inside the room or even outside. If it's inside the room and it's on the search warrant, he has to have Actually, they should take search warrants also unless it is very not possible. Ordinary search warrant चाहिन्छ गरेको murder case or judicial case, if you are going to the place of investigation, you need search warrant. And even if you reach there and think that no, I'll get search warrant, they should get search warrant inside, right? That is more authenticated version of seizure. They do not do that. They straight away enter the house. Okay. They pick up things. This is practically what happens. They pick up things, then they may bring it to the police station or bring it outside the house, and if they find people who are willing to stand as a witness, then please sign out and nothing is going to happen. The fellow will rightly come to the court. Initially, as a judge, I used to disbelieve seizure witnesses, when they said, I do not know anything. Because I thought police are doing things properly. But later on, when I came to know about all this, I believe this is a witness. When I do not know anything, I just say absolute truth.
They just call them and ask them to sign only. Nothing else.
Now, I was telling police, why you want to do that? If you reach the place of occurrence and inside the house you found a weapon of offense, seize it, make a seizure memo. Say that I went there. Now, is seizing equivalent to having witnesses? Also, section doesn't say that. No? He seized it. Is the person who seized it is the more valuable witness to me than the one who are saying yes, he seized it. There are third witnesses. The first witness is telling to me, I seized it. When will I disbelieve unless I have grounds to do so? Okay. Let him seize it. Does any IO goes to the place of occurrence carrying seizure witnesses with him? That's unnatural. You have to go to the spot fast. Things have happened. Bring it as it happened, I tell the police. But they try to make it. No? Now the moment they make the seizure witnesses who comes to the court and says, I do not know anything, now the judge will start talking. If the IO had said, I had no seizure witnesses, I seized it, believe me. Now leave it upon the court to believe or not to believe. Why will the court say, no, there is no seizure witness, I won't believe it. On what basis court will say this? Is a seizure witness absolute requirement of law that will acquit a person despite being convinced by other evidence? No, I don't think so. But the moment you put seizure witness, the court has to listen to seizure witness, right? It cannot discard the evidence of seizure witness. Even if the IO may have genuinely seized it, but the seizure witness is signed later on, and if they say so, then the court starts doubting the seizure.
But even that is not followed, then court may think that it may have been planted by the investigation officer.
No. Why will, see, one thing I don't understand, why will court assume things unless they have a ground to do so? I don't know. For me to think it is planted, I must have a ground to say that, doubt it is planted. If it's not planted, no one can say it is planted. Why will on my own independent basis say it is planted?
Because the scene actually, it's always like this, that the witness comes and he says like, oh no, I had, he had already seized it was in his possession, then we went, then he made us sign the documents, we don't know from where it had been
That's what-
obtained. That's always
Yes,
the,
What I'm trying to tell is, yes, this creates a doubt in the mind of the judge. Because I have kept a witness against the set standards, no?
Yes.
If he was keeping a witness, he should have done it before seizing him. Now that's what I'm telling. When seizure witnesses are put in the case and they say something, that will obviously let me doubt the IO. Now what IO says? IO doesn't say that, I made the seizure witnesses sign later on. He never said that. He says it was done in the spot.
Yes, yes.
So witnesses are saying something else. Now in this case, I do not believe IO, I believe witnesses.
or else he has to follow the procedures in the right manner. He has to, before seizing it, he has to call the witnesses. Then
Yes.
he'll be-
That's what I'm saying. No, that's why section 102 is there. Why this section is there? This section, takes care of practical situation. If I am IO under some murder case, I leave my food and go to the place of occurrence, even if I am eating. Right? That's my job, ordinarily to do. I must be there at the earliest possible so that I don't lose evidence. That's so valuable for me. It's like a gold for IO evidence. As I reach their house, people will be gathered. Okay. I may ask someone to stand as a witness. Maybe they will refuse it. Does that mean I will not seize that object? I have reached the place of occurrence. I'll seize it. I'll say to the court, I have no seizure witnesses. I seized it. Okay. I'll array some of the witnesses who have seen me seizing it. They saw me there doing the things. Though they refuse to stand as a seizure witness and sign on the document, I'll array them as witness. These people saw me doing that very job. They'll come and depose. If they lie, that's their problem. Actual truth, I'll give it to the court. That's what 102 says.
That is the problem, sir. Mostly they try to mold the case in
That's
their manner just to suit a few formalities. Then the case becomes distorted by the time it comes.
See, I think Caesar witnesses are required when you are planning and going to seize something. In that case, we have time to take witnesses. When I'm stumbling upon an evidence, should I go running looking for a Caesar witness instead of taking that evidence into my hand? I would take it. See, any police officer may seize any property which may be alleged or suspected to have been stolen, or which may be found under circumstances which create suspicion of the commission of any offence. Right? Now I tell you the letter section why Caesar witnesses actually are not required in this. I reach the place of occurrence, I find bloodstained cookery. Why should I go and look for Caesar witnesses if they are not available? I'll seize it and make a record of it. Right? Section says so. Number 2 says such police officer, if subordinate to the officer in charge of a police station, shall forthwith report the seizure to that officer. My duty is, okay, I may do it telephonically also, but I'll keep a formal record and give it to the SHO after I take it back. This is what I seize. Now, second, authentic. Things getting authenticated. In this manner also it can be planted, no doubt. But as I said, the court to say it was planted must have some grounds to say. Now in 3, see how it is, creating value for this evidence which the IO found at the place of offence without any Caesar witness. The value, see, he reports to SHO. Third, what is his job? Now the biggest thing, every police officer acting under subsection 1 shall forthwith report the seizure to the magistrate having jurisdiction. Is it done? Finished. This is the procedure. Now even if Caesar witnesses are brought, if I go by this section, I would still doubt because I did not follow. Okay. He has to report it to the Caesar magistrate, obviously judicial magistrate. There is no point in reporting to STM. Though CRPC magistrate means the executive or judicial, unless specifically defined. To such that it cannot be conveniently transported, and where the property seized is such that it cannot be conveniently transported to the court. Otherwise, you have to report to the magistrate means report the seizure document which you have made, take the material before the magistrate. Okay. If it cannot be taken ordinarily, it has given a way out to that also. This is also very interesting. The police he may give custody thereof to any person who is executing a bond undertaking to produce the property before the court. So you were selling the planted thing, right? That is a different notion which are built by defense, planted thing. Because police plant it also, you say. Maybe not, we have not seen such as many cases they would plant it. Okay. But see the section you can give it to someone also they say. So just because it was given to someone, should the court doubt it was planted? As I said, for planted there must be a definite ground for the court. So it's so simple. Even after seizing it, you can give it to the custody of person, take bond from him by police themselves, asking him to bring it in court when required. Usually you will not do, sometimes when you go to seize, let's say a spoon was also lying there. I bet that spoon may have just, okay, I seize it, you keep it. When I ask, I am not valuing that evidence as an argument. I don't need much. But material objects like bloodstained cookery, I will not give it to the custody of someone. So this section is making a situation where things which you have to take it to the court, which you may think may not be required or may be required, not looks very that valuable. You seize it but give it to someone, you can do that also, it is said. Now this says the property has now in a situation, see the IO went to the place of occurrence, no Caesar witness, seized the cookery, reports it to SHO, forthwith, reports it to magistrate. Forthwith doesn't mean immediately. Magistrate may be 1 hour journey back. It will be viewed reasonably, looking in the circumstance, what forthwith means. He will go to the magistrate, even if it is night, magistrate is on duty, report the seizure, and he has to place these items, actually it is placed, he can place it in police markhana also, no problem, he might place it. But actually in other state is placed in the prosecution markhana. And the entry is there in the prosecution record, such and such thing in case was brought by the IO. Now if IO requires that, we can take it out. Now this maintains the chain of custody. Take it out for what? Where did he send this? Again it comes back there. Now when the seizure is reported before a judicial magistrate, the judicial magistrate hears it, signs, scene, date and time, just like a file comes. Now, this leaves less room for the judge to doubt. Just report it forthwith. Why would I know from where would I? Plan को लागि न सामान लिएर जानु पर्छ. Suppose murder case मा मलाई याद छैन मान्छे मार्यो भन्दा पनि भाग्यले मार्यो. If I am planting kukuri, I have to be prepared to take kukuri. If it's a gun, I have to take. All these things will be seen by judge, no? Whether I had an opportunity to plant it. So I don't think seizure, because this section requires for seizure witness, unless you are planning to seize some. But police are putting seizure witnesses in this also, and as against this standard, and they come and say I don't know anything. And once the witness is put before the court, witness will listen to them. From there the dog starts coming. The only seizure witness the section talks about is in section. The Act CRPC talks about is in section. Okay, if you are going to plan it, now if you go, okay, in a boxer case, you reach to a boxer guy, you examine the victim, etc., etc. Now you will say to the, obviously say to the, can you give the birth certificate? And prepare a seizure memo and come back. I don't need witness. Why should I need witness? Just to prove birth certificate.
I think a simple handing taking memo would also work.
Not seizure, because it has not been
Okay,
seized.
no problem if I can, but still for me that is also not required. If I can trust the IO in his processes what he has done. IO को बात त के हो process त हो. Substantive evidence त जुन म convict गर्छु acquit गर्छु त अर्को हो नि त.
And the person who gives, like father, mother.
Yes, I gave it to him.
Yeah,
What is
that
that?
will suffice the matter.
Now police are bringing the birth certificate to the police station, calling someone, two witnesses.
Then they.
She is at
everything
house.
falls.
Now the fellow comes and yes, it was in police station. Go on, finish.
That is.
You should have told me. I took it from home, from the father. I did not make seizure memo. Why will I disbelieve him unless I have grounds to do so? What's wrong in that? He may not have followed the procedure they might say. But where does the procedure say it has to be seized? I went to the home during investigation. Okay, I may be sitting also without asking birth certificate. The father comes with the birth certificate to me and gives me in my hand. Should I not take it and wait? Oh, I know, I need seizure witnesses. Where they are? Should I look for them? It's a fact which I got. He's giving me. Okay, I might say to him, I bring seizure witness, don't give me now. He might insist and put it on my lap also. Now, should I throw it back? I'll put the truth before the court. That's what I tell. And when I look into the section, no section mandates there to be seizure witness. Seizure memo is a format. You put witness genuinely well and good. But if you are not finding time or if the situation is such that you do not get seizure witnesses, come and seize it and tell the court I did it and this is what
Then
happened.
they keep the witness. They don't even tell them why they are witnesses.
Because-
Just sign on this document.
Because tell me one more thing, okay? Let the seizure witnesses also come. In a birth certificate has been seized. There are two witnesses genuinely seized inside the house itself. I took the seizure witnesses also. Witnesses also comes and say yes, it was seized from the house, from the possession of the father. Okay, does that still make me, as a judge, feel that it was with the father, therefore it's a genuine birth certificate? He might have brought it from somewhere else. So what is the value? The ultimate value is the substantive evidence which proves that document. What about Caesar? Now the Caesar witnesses take opposite is unnecessarily creating a doubt in the court of the court. Because it was made up. Why to make up? I told I was so many times, but they want to do it. But the moment it goes to SP, where is the Caesar witness? If he has done that, no, I don't care. You put
Follow
two
the
signatures, whether you
formalities
put it or whoever you put it, this is the problem. These are the bottlenecks actually. And I've always said, I have given training to IOs also in this very academy. I've always told it's not you who needs training. It's at least DSP and SP who needs training. Only one. They are not understanding. And what do a sub-inspector can do? I don't know in law why sub-inspectors are given charge of investigating. It should be either SP or DSP at least. Let them investigate. These poor fellows, put them in law and order. They are very inexperienced. You people, and very subordinate to the very high levels in the police. And police's hierarchy is very difficult. You have to obey the order. So how will they work? Even if they are said to do something else, they will do it. They have no choice. They have their career, they have their family, they have their life, they have their own personal thing. Why will they? Because I have seen, new SIs very energetic and full of energy trying to do something good after 1 year, or even 1 year, I see the same person demoralized. So I wouldn't blame them. They have told me directly, sir, it doesn't work. Why you are taking 164 in this aspect? Not required. You might break your case. I told them, why that 164? So this is a legal job. So they are not allowed to apply their mind. That is the bottom line. Law itself has no bottom line. Believe me, this CRPC has no bottom line.
So what about the SADA codes? Why is there such a it's the legislation itself is not good. Technicalities, so many technicalities are involved.
No, because as he said, the word planted. Drugs cases,
There are more
the
chances.
legislation is such that you can plant it easily and prove it also that it was found from his possession. That's why these many cases which requires search before a gathered officer. That's why these provisions are there. And believe me, if you follow this procedure and it is an actual case, there cannot be acquittal. The law is like that. It has safeguarded the accused, but if the police follows the procedure exactly, right, then the person can be convicted 100%. These drugs cases.
SADA is like
Police are breaking the procedure, no? Procedure,
Yes.
because it's not the procedure, very important. Drugs cases.
90% cases are acquittal.
No,
Even for marijuana.
100%. There are no
See,
conviction.
I had done a NDPS in marijuana, brown sugar also. Special type of marijuana where the lady had grown in Pantang all over and selling from there, okay? And then one, I forgot exactly, police did not follow one procedure and there were judgments which said, it was absolutely, she was selling it, everything was proved. But police did not follow one procedure of, I think, informing the SHO before going to that place. That and there was direct section 50, direct judgment on it. Forget it.
For that also, I think it's to the police department. SOPs. I think the police department should take out SOPs with regard to the procedure required for that thing. Then only I think they will act
Yeah,
upon
but for this, as you told, definitely this should take a but for this, we need someone out there in the police office at the SP level who is interested. They're not interested in the investigation.
Actually, there are some good working officers. For example, we have our court inspector, Mr. Thendu. He is a very good officer. And what he is like, he is helping us out and finding the lacunas in the investigation and all the faulty charges. He was looking into it, and what happened was he went to then we had given a list of these are the shortcomings and all that. Then he went with whichever, he made everything from all the course and he went to his higher authority and he said, oh, very good. Now, so you yourself, you find other officers who are like you and make some SOPs and all. They put it on.
That's why he's good inspector.
He's a good inspector, but like
No,
people.
I'm
Yes.
opposite.
Yes.
That's why he's good.
Otherwise, he
I've known him since I was in North, he was in Chungtang, etc. In fact, his own personal case I had acquitted the accused. But he was someone who wanted to learn. That's why he's there.
So
There are some
saying
good-
like saying, oh, तुम तो बड़ा काम करते रहे हो. Then one of the officers he said, tell him to do his work as SCI. Don't tell him to vet the charge sheets. Because he was finding faults in the charge sheet, so he was telling him, I said, tell him to do his work.
good officer are either CI or in the officer administration.
Actually, there are those, to make things better, those things are there, display boards in the MG when advertisement is going on. Some kind of pollution index is but all wrong, it's just not happening. I think they should give the number of convictions they achieved in a month. They'll be at such a shameful state. So in drugs case, I told you, you can be planted very easily and someone innocent can be. That's why it was a very strict procedural law.
That means the legislation itself is good, but the investigating agencies are at fault.
Because drugs cases are such that you have to find someone in someone's possession, you say. And then
Because that
that can be easily done by police.
Actually, it's not in my court. I don't deal with the SADA cases.
See, to
but
commit theft, for someone who is firstly implicated in theft, some theft must have been occurred, no? Police must show that as an evidence. But for drugs, what they need to show? I was found in it. Finished. Now, if that is the only requirement, everyone will get convicted, every innocent person. But to balance it, the procedure has been made so strict that it's difficult to plant without violating the procedure. Because even after 5 people, even the police or whatever, 4 maybe let's plant against it. 1 might still be there, let's not do it. So this fellow will offset. So looking into these things are
Because Sikkim, I think like most of the cases we are dealing with is SADA and POCSO. Because I think in Gangtok we have around 200 plus SADA cases. In our courts we are like more than 168, 69 POCSO cases. So POCSO could at least a little bit okay, but regarding SADA it's like very
stop it,
100%
folks at the
It's
yeah,
too
she's a
and
stop
bad.
it. I have seen because absconding SADA cases हामीले गर्दैन त the office side, the magistrate गर्दैन, even ND cases. Every time same fellow coming.
One person I know was that lady. She's from my church. She was telling me like, these are the people. Why do they arrest? And what we should do? We should take them to border area, keep some tablets, give them money, and tell them to go right out and fight against the outside.
But this is also, to my understanding, what is a violation of law? When you have made something, just only person thinking more literally and broadly, okay, leave the law alone. I am not saying that the people taking drugs are absolutely good people or they should not be punished. I am not saying that, but I am looking at generally as a general perspective. Now the people are taking alcohol also.
They are not.
This does not affect. Now they say these drugs are more likely to damage people. Of course, alcohol also does. Let's not look at the difference in severity. Alcohol we sell it so openly. In fact, you can eat in open market, drink open market out there. Okay? Now, if one fine day we make alcohol also against the law against the alcohol and punishment, then all of them would be in jail, right? So, of course, it's a legislature's thing that they made a law banning something else. But people just like they say, let's send the alcohol. If you are saying something, have a balanced view. Send the alcohol, people taking alcohol also to court. Because people, generally they say things without understanding things behind it. And that
But
branded
I
addicts also.
think there should be some way out for us to deal with these SADA cases now, because we are just keeping them in jail and making them healthy, come out and again start it again.
No,
And I think they are worse than
See,
murderers.
no,
They are worse than murderers.
See, why we are failing another thing is,
Yes,
we won't be able to stop any crime in society. It will grow more. Now people say, oh, what's happening in Sikkim? We are developing crime, different types of crime. More heinous crime. Believe me, there might be instances which we have never seen, like murder. We have already seen murder in that new market. It was a murder.
Yes.
Allegedly, the vehicle.
Ram.
It's a murder, allegedly. Okay. We have not seen. So the crimes will increase. Now, in SADA and these drugs cases, see, I have a doubt. We get so many consumers. There must be sellers, no? So, sellers should be. The police at some point are targeting the sellers through the consumers, but they are not more able to prove the case against the sellers.
Big fish
Then
are
the
always.
sellers are escaping more easily under SADA. Okay, then otherwise it will not stop. But I can call this from this. I do not know reason why. Because I feel when you are entering from Bengal side, from the new bridge, there's absolutely no checking. Have you noticed that?
yes.
Yes,
That
yes,
I
no
notice.
They
That I
just drag the vehicle normal. And then maybe because of a belief that the only taxi vehicles go other way, mostly it's carrying taxis.
Right.
So now for these peddlers, they know this.
Yes.
It's less checking out there. Let's use private vehicle. I've seen that few instances they have done it, only of the known one. So that's why I don't hear much SADA cases nowadays in newspapers. Could be that one of the reasons. There could be so many other reasons also. Nowadays I feel, because even if I see, I do feel a little bit of deterioration of law. The HMR way, parking is so haphazard now. Previously it was not like that. People can park anywhere now. And new market parking has also extended it so wide, it's so difficult sometimes to squeeze into also. So I think that kind of things are not there. People are quite free now. This could be the reason why SADAs are not there. Yes, but anyways, when I was seizing in 1990, a lot of heroin
also is coming up.
These days, people are more into this brown sugar.
Brown
and
sugar,
even
more.
people from the Pakistan their side, the Ravani, I think that's rampant now.
जोरथाङ त खादिने थिएन सबभन्दा जोरथाङ त
Just
Oh,
also.
Rotan is that. One more
Sikkim also.
I have seen one section. What was that? Just wait a second. I think anything we can talk about. The bottlenecks are the actual practices, no?
Yes.
Not the law, except a few sections. If they break up there, we'll also break up. Okay, that's one.
See, sir was talking about small khana entries.
Oh.
It is very important even if
Yes.
there are cases.
And even in other states, is the from prosecution branch. One
It
fellow
never
received
made.
it are the witnesses in the case.
They never make, not in a single case they make
Even
mal
those
khana entries.
NDPS and SARA, if the Malkhana record is there, it will help,
They
help the
They have
prosecutor.
started now because we
Yeah.
made that complaint, I
Yes.
told you, no, to the CI.
They should
They now,
forthwith
yes.
report the seizures to magistrate.
And even there also, the seizing officer is to keep there, after 3-4 days, they have to take to the, IU comes, then after 2-3 days, they will take to the Malkhana. So in between that.
And one more thing, let me tell you. Does police officer have, you have seen inquest report?
Yes.
The police have power to make an inquest.
They always go to the bench.
They will. Which magistrate?
They go to
Executive.
executive.
Branch of the executive.
So police also have done it.
Yeah, police
पुलिसले
officer.
त आफै गर्छ
गर्छ, पुलिसले आफै गर्छ।
But why is मैले देखेको
Even judicial magistrates have no power, except executive magistrates. So what police can do is they are using the same form, no inquest form. Police पहिला जान्छ नि initially. They should not use that inquest form under 170 or 1 section. They should not use that. Police can go and inquest has a different purpose. Inquest has more value, more detailed examination. Okay? Than police going and just looking, observing from front and making. They can do that, no problem. That's not inquest. But when a magistrate goes to inquest, he goes into more detail. Inquest has a legal value and basis. So police does the inquest form used by the same as what the magistrate is doing and go by law. Even I didn't know it. Okay, in one case, Hon'ble I could have said because in custodial deaths, it's the judicial magistrates which inquire into the death. Okay, so even I was not aware. All of us were making inquest. The High Court pointed out that where is your power to do inquest? It's only the executive magistrate, either DM, STM, or whatever. Where the
In question that happened with the board case, in that man, the magistrate गरेछ आयोले पनि गरेछ र बोर्ड फर्म चाहिँ फेरि आयोले फिल गरेछ डिटेल सिग्नेचर मात्रै एसटी त्यो एक्विटेड भयो
अब त्यो प्र्याक्टिकली के छ स्टेटले पनि भन्यो होला भाइ बनाउनु सहयोग गर्ने
Easier for him, convenient for
जस्ट
both.
त्यो साइज मात्रै गर्यो त्यहाँ अब त्यो लेखेको छ क्रसमा यो भनेको बुझ्छ यो भनेको पनि सबै बुझ्छ एउटा केसमा चाहिँ एक्जिक्युटिभ
कुनै executive can do it. Except in custodial death also inquest त गर्नु अरूले गर्नै सक्दैन इन्क्वेस्ट त अब सेक्सनको रिक्वायरमेन्ट what you go and see can and the drops case map absolutely drops case map valueless. What will the court do with the drops case map? It doesn't even know its value. यस्तो टर्निङ ल्याएर गाडी लडेको त्यसमा त्यो टर्निङ कति इन्क्लिनेसन थियो कतिको हाइटमा थियो यु डोन्ट नो एनिथिङ युजलेस आइयो हिमसेल्फ इज सेइङ रफ वाट्स द भ्यालु अफ रफ स्केलमा हो भने चाहिँ अब and one more thing I tell you okay 311 I think you should object to the court I have faced usually 311 ma suppose you are filing an application what does the defense say
Defense objects saying that we are filing in a related stages, mostly.
When do they tell that? When do they tell that? What? Let's be practical. You are judicial, and judge in fact, you are not 311 application. Okay, the defense will come, you leave a copy to them. What they say at that very moment? Without reading the contents.
Mostly, they don't
They
object.
don't
in most,
object.
They don't object, but they'll say that we're trying
We are
to.
trying to fill up the lacunas.
They much and delay the matter.
No, that is a later stage. I am understanding. त्यही दिन hearing हुन्छ.
हुन्छ कता
त्यही दिनै.
Sometimes it
Mostly
Mostly
that day only.
Okay, that's well and good. If the defense says, I need time to file reply,
then he must be given, I think.
you must be.
Given opportunity to
Then
file.
we,
Why?
but that has never been the instance as such.
Yeah, Mr. Mohammed, why?
Basic time because
Basic.
they need-
Defense, that's the
Preparation.
first thing defense wants is time.
Yes.
That's why I asked this question. But I was quite surprised when people were saying that, they don't object that. Usually they don't object.
They don't object and like
Why,
they,
Mr. Pokhran?
Yes, I don't know why, but defense has, in one or two cases in Gangtok, they have filed an objection. It's like Android or
They say that it is just on, this is just a delay.
You have seen that practically, no?
Yeah.
What was the type of case in which that objection time was asked?
it was something like, I think,
And who was the person that prosecution wanted to examine?
POCSO cases. I think one witness, he was witness to some certain agreement, like that they have made some agreement between the family of the victim and the accused. Later on, like they have settled the matter or something. So that witness.
To my understanding, yes, giving time in certain circumstances when the judge thinks, let's say the other side of this, absolutely alright, okay. But usually, what does 311 say? Any court is the power solely of the court. I don't need application also if I feel I want to summon someone. I don't need to give time to anyone. I'll examine.
Yes,
Whether
court
it's relevant,
relevant,
irrelevant,
yeah.
it's my is court's full power. Any court may at any stage, and believe me, if courts want to examine something, the trial court, no higher court will say, don't examine it if it's applicable. It was that court's mind, no? Any court may at any stage of any inquiry, trial or other proceeding under this clause summon any person as a witness, any person, or examine any person in attendance, though not summoned as a witness. Charge sheet ma हुनुपर्छ भन्ने जब रिपोर्टमा बसिरहेको छ भने if I find this fellow is relevant, I'll examine. And re-examine a any person so and so. It to be essential to the just decision of the case. Okay? So why to give, suppose you prosecution or even defense the parallel application saying this witness is so and so, I have the case before. The moment I feel as a judge, yes, I want this witness, I will not give time to him. It's my understanding. I'll give my reason. You ask me. You take your time, I don't care. I'm someone.
Yes,
this has happened.
But in some places, you know,
This
where
has happened also.
in some places where I feel no, the witness is not very clear to me also. Then okay, if I'll reply, it's not.
Or say,
Maybe I can lighten from there.
or say one
It's-
in one
it's- in
case,
some of the
judgment
cases,
was
yes.
pronounced. Judgment was pronounced. Then after that, what happened was like the accused person's mother was examined, but his date of he was in the borderline. So there was nothing on record to prove his date of birth. And his mother was examined, but we as a prosecutor, we had not led evidence in that aspect regarding his date of birth. Then the court was very unsure as to whether to about the age of ascertain the age of the accused. So court he questioned. Then the court questioned the defense after judgment, after arguments before judgment. So the court asked the defense as to why you didn't ask the date of birth to the mother, because she would have been the best person to ascertain his age, because he appears to be a juvenile at the time of committing of the offense. So the defense said that it was prosecution's witness, they did not ask. Then I said it was not upon us to prove his, because we are saying that he's a major. Why would we just, it was up to you, that was your call, I said. Then the court himself called the witness, again, re-11, and then we examined her, and she came and she told the correct thing.
Yes, especially in POCSO cases, Procedural Laws used to call, if the mother or father were not arraigned, then he himself used to call. Because he used to say that it's mandatory, I'll call them. That's going to exam.
Yeah, in this one, but I think one thing you should keep in mind is, just 1 minute, sir. One thing you should keep in mind is, yes, they are the best person. The best word used here is in the context. If you collect different evidences, this could be the one which you can rely the most. It is not saying that, they are the best, it should be believed. parents is brought as a witness and the defense creates a doubt, then court may not rely. They are the best source of evidence, but not the best evidence. That is what I understand from my parents. Otherwise, every time, why should you bring birth certificate? Police will every time put parents' face.
Yes.
I would still look for birth certificate. You know, in some cases, when the parents have also come and they have deposed something and defense have done nothing, okay, I rely on that. But I would look for birth certificate more than the parents as a judge. Parents like you by security
बर्थ सर्टिफिकेट त्यो प्रब्लम हुन्छ सर द्याट समटाइम्स बस्तीको मान्छेहरूले बादमा बनाउँछ बर्थ सर्टिफिकेट त्यो पनि प्रब्लम
And कतिवटा पेरेन्ट्स आएर नै देख्छ त होइन हामीले त बर्थ सर्टिफिकेट निकाल्दाखेरि एज घटाएर निकालेको
भरे parents बोलायो हो parents बोलायो
There is backfire.
No, if you think that parents' evidence are best evidence, then parent आएर 20 वर्षको भन्थ्यो भने सक्यो त
This is observation High Court, Honorable High Court.
the person may actually be 70.
No, actually, these parents, like Honorable High Court, and observe in different judgment, like parents are the best person to.
Yeah, I know, no, but I is not saying that, in what context they said. There was no other evidence in that case. In that context, the parent had given the evidence. So, only having that, I was saying, it still did not mean that, among all of the evidence, they are the best one. Two circumstances. You can best ever rely on that. Otherwise, don't bring birth certificate in box. Still the eye goes. Bring the parents. Then that court will say, court will question, where is the birth certificate? By parents. And so we are done.